9:15. Let us kick off. Welcome to this hearing to budget estimates, the second hearing for the Portfolio Committee number 1, Premier and Finance, for the additional round of budget estimates 2025-2026. Firstly, I acknowledge the Gadigal people of the Eora Nation, the traditional custodians of the lands on which we are meeting today. I pay my respects to elders past and present and celebrate the diversity of Aboriginal peoples and their ongoing cultures and connections to the lands and waters of New South Wales. I also acknowledge and pay my respects to any Aboriginal and Torres Strait Islander people joining us today. My name is Jeremy Buckingham and I am the chair of the committee. I welcome the President of the Legislative Council, the Honourable Ben Franklin, and accompanying officials to this hearing today. The committee will examine the proposed expenditure for the portfolio of the legislature. I ask everyone in the room to please turn their mobile phones to silent. Parliamentary privilege applies to witnesses in relation to the evidence they give today. However, it does not apply to what witnesses say outside of the hearing. I urge witnesses to be careful about making comments to the media or to others after completing their evidence. In addition, the Legislative Council has adopted rules to provide procedural fairness for inquiry participants. I encourage committee members and witnesses to be mindful of these procedures. Welcome again and thank you for making the time to give evidence. Mr. President, I remind you that you do not need to be sworn, as you have already sworn an oath to your office as a Member of Parliament. For all other witnesses, I will remind you that you have already been sworn before the committee during this round of budget estimates and therefore do not need to be sworn again. Today's hearing will be conducted from 9:15am to 1pm with a 15-minute break at 11am. During these sessions, there will be questions from the crossbench, opposition and government members, and in accordance with our resolution, we will begin with questions from the crossbench.
Do we not need to swear in?
Oh, no,
This is additional estimates. So we did that last.
No, everyone's been sworn.
Wonderful.
Yep, everyone's been sworn. Is there anyone online? Miss Boyd? Well, in the absence of crossbench questions...
You must have some, Chair.
I do, but I'll wait a little while later for those. We'll kick off with opposition.
Thank you, Chair. A nice, pleasant surprise for a Tuesday morning. Good morning, Mr. President.
Good morning, Mr. Fang. How are you?
I'm fabulous. Mr. President, obviously I think the biggest event that's occurred in the Legislative Council for quite a number of years has been the issue of Cullen versus the President.
Indeed.
It's probably no surprise that I'm going straight to this.
Not at all.
I guess the first question is what has led us to this point, and what is the current situation in relation to impacts on the Legislative Council?
Yeah. Look, I'm really glad that you raised that first. You're 100% right. It is the most important issue that's happened in the last 6 months, and frankly, it goes to the heart, I think, of the whole effectiveness of the Legislative Council, potentially. Our House is an incredibly important one, and it has responsibilities to oversee not only the government and not only to be provide appropriate checks and balances to the government, but in fact to all range of organisations, people, and so forth in civil society. And so therefore, part of the way that we do that is through inquiries. As you know, you are an active and excellent participant on many, and those inquiries, I think that all of us have said for many, many years, are some of the most important work the Legislative Council does. They often are done in a really collaborative way, but are certainly always done in a way where they look at issues very deeply and seriously. To do that, they require witnesses to come and give their expert testimony. Now, sometimes, as we are all aware, witnesses don't particularly want to do that. One of the great strengths of this Parliament, one of the great strengths of the upper house inquiry system is that since 1900, under the Parliamentary Evidence Act, there has been a form of coercion to say, if you don't want to appear voluntarily, this Parliament can make you do so. And under Cullen versus President, under the case that was taken to the Court of Appeal, that's now been overturned. Not because of the fact that the Parliament, that the Legislative Council doesn't have the power to compel witnesses, but rather a much more limited issue in terms of the cable doctrine, which is that the Parliament cannot compel the Supreme Court or a Justice of the Supreme Court to do something without them being able to exercise discretion to do so. And that is understandable. That was always a potential outcome. And so therefore we now find ourselves in a position where witnesses can't be compelled to attend. The challenge with that, of course, is that 90%, 95% of witnesses will attend anyway because they understand the importance of the committee system, they understand the importance of Parliament. But it's in fact that final 5% of witnesses that we actually want to attend that need to attend. Now, we are now at the stage where, as you know, the judgment has come down. We have sought leave to appeal to the High Court. We've put in our submissions and so forth, and the clerk might have more to say about this in a moment. As he's legally trained and I'm not, but I've had a big crash course. We expect, just for your information and the information of members, we expect to hear back about whether that leave will be granted, special leave will be granted in April, and we would expect to for the case to be run probably in August, with a judgment probably being handed down at the end of the year. Now, that of course that hasn't been told to us by the High Court, but from all of the experience of previous cases, that's the sort of timeline that we have. My view is that it is important to run that case, obviously, and I hope it lands in a good place. It may not. My preference, which you would be aware of, was that we should look to legislate, and I note that a bill has now been introduced, and we'll see how that goes through the Houses of Parliament. But I do fundamentally agree that compulsion is critically, having the threat of compulsion is critically important to ensure that we hear from the witnesses that we need.
Maybe not a threat, but a method to compel?
A method to compel, beautifully put. But Mr. Reynolds might have some more to add.
Thanks. Mr. Fang, I just endorse everything that the President says. For an effective committee system that has a scrutiny and accountability role, the ability to enforce attendance is really important. I have some details here to give specifics to your question about the impact. As members would be aware, the summons that gave rise to these legal proceedings was issued by the Privileges Committee to the Premier's Chief of Staff in the course of its inquiry into possible contempt from the Rose Hill inquiry. In particular, the summons was issued as part of the committee's investigation into the unauthorised disclosure of the Select Committee's report, deliberative minutes, and the circumstances in which the Premier and his office became aware of the information. The Court of Appeal's decision means that effectively that line of inquiry by the Privileges Committee is now closed, as I'm sure you're aware, being a member of that committee.
Correct.
Other inquiries that may be currently impacted by the Court of Appeal's decision, and this is where committees have already summoned witnesses or may have wished to summon witnesses in future. The Public Accountability and Works Committee inquiry into the integrity, efficacy and value for money of the local small commitments allocation process that has previously issued summons. Again, that same committee's inquiry into matters of impropriety relating to Bayside Council, that's issued summons for that inquiry previously. Again, the same committee's inquiry currently into the Electoral Commission administration of electoral donation reporting, that certainly has threatened to issue summons.
Suggested that would issue summons.
Yes, suggested. The Select Committee into the failure of the playing surface at Allianz Stadium, probably early days, but there's some possibility that might...
I serve on that committee as well. So, well aware.
It's probably a coincidence.
Yeah.
Portfolio committee
Perhaps not.
Portfolio committee number 1, Mr. Chair, which you chair, the inquiry into unsolved murders and long-term missing persons cases in New South Wales. That would certainly look to be an inquiry where you'll possibly have reluctant witnesses. Portfolio committee number 5, inquiry into identity protections proceedings involving children. That, I understand, has also...
We might actually address that one a little bit later, because that's probably a question 3 or 4 on my list of matters that I will bring up. So, yeah, I'm aware of that one as well.
So they're the ones that we've identified that may be affected by this. I mean, we've got 42 inquiries at the moment, so there's a whole lot of other inquiries that are completely unaffected by this, because, as Mr. President says, most witnesses will turn up voluntarily, and we will certainly monitor the effect of the invalidation of Section 7 to 9 of the Evidence Act.
And before we go on, can I just reinforce how significant this is? I mean, for 125 years, this Parliament has worked under the assumption that the Parliamentary Evidence Act of 1900 was valid. And although no summons was ever issued, the potential utilisation of such a mechanism, I think, had an encouraging effect on witnesses for that 125 years. We are now in a very new period, and it's very important for the Parliament to work out how it's going to deal with that.
A timely resolution is important. Would that be a fair characterisation?
100%.
Okay.
Could I just jump in there, please, Mr. Fang?
Sure. I mean, you can join the opposition instead of being in the government, but sure.
Thank you, Mr. Fang.
welcome,
Just
Chair.
a clarification. So, just in the timeline for the appeal,
Yeah.
Can we just clarify, just for clarity? We are seeking leave to appeal the decision. When is the determined?
Yes.
We're expecting the decision on our
on whether we're allowed to actually appeal. April. It is. Look, again, this hasn't been a time frame which has been formally given to us by the High
course,
Court.
yes.
This is on best estimates that we can make and that our legal team have made.
Yeah.
But what we assume is that April will be when we'll find out whether we're actually able to appeal or not.
Yes.
And then if we can, then the case will probably run about August, and then we'll probably get the decision at the end of the year.
Okay, thank you.
So for what it's worth, the likelihood, the assumption that we're working on is that we are hopeful we will be given leave to appeal.
Okay.
But again, obviously that's out of our hands.
Sorry, Mr. Fang. Sorry to interrupt.
That's
Over to
okay,
you.
Chair. Thank you. Very cordial this morning.
Thank you.
No calls yet. Good. Mr. President.
Yeah.
It's a matter of Placido.
Well, let's just. We're going well. Let's just keep the boat sailing straight. Mr. President, obviously, prior to the Chief of Staff of the Premier taking action in the Court of Appeal in relation to the powers of the Legislative Council, there would have been a number of communications between the parties in relation to the arguments that were being made against the Legislative Council's ability to call members of staff, of members of Parliament and ministers. You've indicated in your answer that it was the cable principle that was the predominant issue that negated the ability for the Parliament to issue a summons under the current framework that we have, which is that the President
invalidated Section 7 to 9 of the
that
Act.
you can't go to the Supreme Court to get them to sign the warrant. That's the issue.
Yep.
Did Mr. Cullen ever raise the cable principle in any of his communications prior to lodging an appeal with the Court of Appeal?
I can't remember. Mr. Reynolds may have information on that. We're definitely happy to take that on notice. I'm very happy to answer it. I just don't know.
I think I know the answer.
I don't think we have that information. I mean, something like the cable principle is the sort of thing that lawyers advising a client would come up with, rather than the client themselves. Is that what you mean? Did the Chief of Staff himself raise?
Yes. So in effect, in seeking to bring an argument to the President and the Parliament, the Privileges Committee, in effect, to say that a Chief of Staff should not be called, and reasons that were in support of that, and I'm sure there were a number, was the cable principle ever raised prior to Mr. Cullen engaging legal services and counsel and lodging a case with the Court of Appeal?
Yeah, no, I understand the question. I don't have that information in front of me. I do remember when Mr. Cullen's lawyers originally wrote to us, there were a number of different aspects that they took issue with about why potentially he wasn't able to be called. From memory, there were 3, but I just don't have the letter in front of me.
My recollection, the Privileges Committee were given, you would understand from being on that committee, that they were given a letter by him explaining why he shouldn't be summoned.
The cable principle was not raised, though, was it?
But just to clarify what we're taking on notice, are you wanting to know whether he himself raised it directly or whether his legal team did?
Yes, so in any time prior to announcing that he was seeking to go to the Court of Appeal and there being a case lodged with the Court of Appeal, did Mr. Cullen ever raise the cable principle?
Yeah, he or his legal representatives?
Well, I believe it was only he at the stage before he engaged. But yes, prior to there being and the reason I'll come to in a second. But
sure, it's a valid question. I understand the point where we don't have it here, but we'll definitely take that on notice and let you know. And
so the point is that if he didn't, I believe that we were saddled with the costs of that case. Is that correct?
It's certainly a very expensive case that is going to cost us significant amounts of money, yes.
We haven't paid it yet, but that's because obviously we're appealing. So.
Yes. So in circumstances where, I'll say an appellant because it went to the Court of Appeals, but effectively somebody brings a case where in circumstances prior to it being brought before the court, the argument hasn't been made and an opportunity for the matter to be resolved, like the issue of cable, how is it that we are responsible for the costs to pay for somebody to bring the case?
I'll throw to Mr. Reynolds on that one.
Well, I guess whatever the litigant raised prior to the litigation, it really just, I'm sure the lawyers here would verify, it's really just the legal argument in the case and then the judge's determination that determines who's going to pay the costs.
Were they scaled costs or were they indemnity costs?
We're paying, I think, it's around 60 to 70% of the costs, of the total costs.
Okay, so in those circumstances...
We don't know what those are, I should say.
And obviously
so we're
still going through the process.
Yes. Yeah. So do we know what we have paid in relation to legal fees in order to defend the Legislative Council against this action?
A lot.
Yeah.
It's in the hundreds of thousands. I could take that on notice because we actually received a fresh bill late yesterday. So we
timely as it was. Yes.
Our lawyers are great. They're very professional. They're very efficient. They're very responsive.
I think I made.
But they're also very efficient in
billing us. No. I mean, they tend to be that way. I think I made the quip last time that that they were somewhat cheap to receive the advice in relation to the Dural Caravan, and I might have been a bit quick in speaking. However,
Yes,
guess...
so I can take that on notice.
Yeah, I guess the crux of it is, and from the opposition standpoint, the Premier's Chief of Staff has been funded, in effect, by the government through I imagine the Attorney General, through a grant to actually take the Legislative Council to court to try and lose powers so that he didn't have to appear and provide transparency around an issue. That is extraordinary to me, and I don't think that that's actually been ventilated quite enough. The question obviously arises is how much has this cost the Legislative Council now? And even if we are only paying 60 or 70% of Mr Cullen's fees, how much is the taxpayer funding Mr Cullen in order to have avoided transparency?
So we are very happy to take that on notice. And in fact, if we can get you a figure by the end of the hearing of where we are at the moment, we definitely will. So that's sort of the answer to your second question. In answer to your first part of the question, I mean, that's really a political issue.
Oh, I know. And I appreciate that. It was more said as a statement than a question.
Indeed. So obviously we don't.
I appreciate that you may not answer that, but it's on the record now. I guess the last part is that when you wrote to members to indicate the initial decision to not appeal, you indicated that it was the case that you hoped for a solution that was not one of a legal standpoint, but perhaps more of a legislative solution. I note that you've raised the issue that the opposition, supported by the crossbench, have brought forward a bill. I guess in the spirit of ensuring that the Legislative Council retains its powers, and noting your comments related to the wanting to resolve the matter, have you raised with the Premier directly that this is a solution that has the support of the opposition and crossbench in our House, and that the two issues aren't mutually exclusive? We can find a legislative response to this whilst also continuing our legal challenge to the Court of Appeal's suggestion. Have you raised it with the Premier?
Mr. Fang. Mr. Nan,
what are you covering up?
The President's probably more than capable of answering the question,
He is.
but it doesn't change the fact that it's not relevant under the procedural fairness resolution to the terms of reference of this inquiry. That is not a question that's related to the estimates of expenditure from the consolidated fund. It's a political question, and I don't think it's in order.
No, it's a parliamentary question. To the point of order, Chair. It's a parliamentary question, noting that the President did write to members saying that he was seeking to work with all sides in order to resolve the matter in a legislative way. I'm seeking to understand if the President, in honouring that commitment to members in the communication, has sought to directly liaise with the Premier about a solution that is currently on the table and would very simply make a small change to the Parliamentary Evidence Act to provide the President himself the ability to issue the summons, which would restore the powers to the Legislative Council.
I think I'm not going to uphold the point of order because I think you're both right. Because
I'm more right.
No, I think you're about 50-50.
Okay.
Because it was a question about process, but it also asked a question about whether or not the form of the communication, and whether or not you had the President was asking the Premier if he was aware that there was political support for a particular remedy to this issue. So part of it I think fell within the terms of reference, and part of it fell without. But
I'm very happy to answer the question.
Please do.
Yeah. So the short answer is no, but the longer answer is yes, you're quite right. I've made it very clear, and I'm sure the Premier, as many others would be aware, that I do think that there should be a legislative response. As you quite rightly refer to my statement of the 29th of December, which I'll just read that small bit of it.
Yes.
That I think that there should be, quote, an appropriate legislative response to the matter, unquote. And then it goes on to say it's clearly necessary for committees to have an effective mechanism for taking evidence from witnesses. The legislation that's been proposed is one potential legislative response. I think it probably wouldn't be appropriate for me to actively lobby for that specific response, because I think there are other potential appropriate responses. That having been said, I suspect the Premier's office and others may be listening, I will make it very clear that I do think this is an issue that must be resolved, that the House must have these powers in order to be able to ensure that witnesses attend to inquiries. I do think a legislative response is appropriate, and I would encourage all members across all sides to look at all potential appropriate legislative responses to resolve this matter.
See, wasn't so bad, Bob.
Sorry, that's inappropriate. Call myself to order. The government, His Majesty's
Have a swing, Murph.
government.
Thank you, Chair, and thank you, Mr. President.
Mr. Murphy.
officials, for coming today. I'm just going to ask a few questions about one little issue before I hand over to my colleague, Mr. Nanvar. It may well be Mr. Webb is best directed to answer the questions. I received an email on the 19th of February this year stating that we're updating and refreshing the Parliament of New South Wales crest to a new design, which there were links in the email to look at. Can you just explain to me what the change is in the crest? Is it that if you could call it the bridge of the crown, is now circular instead of a dip? Is that the only change in it?
I will throw to Mr. Webb to speak on this matter. This is, but I'll just give some very brief framing remarks. You're quite right to point to the crown. There is in fact a new crown with a new monarch, and therefore the crown that sits on top of the crest of the Parliament needed to be updated, and that's predominantly what's happened. And that was a decision taken by the SMG, i.e. the two clerks and the head of DPS. It's rolling out appropriately. It's digital. Any digital paraphernalia is being changed with speed. Anything that has that is of a concrete form, letterheads and other bits and pieces, won't be pulped. You'll be delighted to hear, Mr. Murphy, but they will be just changed at the time that it is appropriate to do so, which I think was, in fact, in that very communication that you talk about of the 19th of February. But I will give to Mr. Webb to speak more to this issue.
Yes, no, the primary, as you quite rightly point out, the primary change to the crest is the move to the Tudor crown. Each new monarch picks a new crown, but because Queen Elizabeth was monarch for so long, the crown obviously didn't change through that period. The opportunity was taken to make a couple of little updates. The tiny line in the middle, its face was going in the wrong direction. We've never bothered to update, but given we were making other updates, we made that update at the same time. And there's been little changes to the seal as well, which again in the past we haven't. The minor changes, and so we waited for there to be a more major update before we made those changes. So we caught up on a couple of little changes, but the primary one was the crown.
So I'll just give you one final bit of information. The issue was actually reviewed through the New South Wales Government protocol process, and that was done including in consultation with the protocol team in the Premier's department as well. So just giving you that information.
So, at the moment, this is being rolled out in relation to digital assets, for example, what goes on the bottom of an email, a digital signboard and so on. But
though I note on that particular one that's in front of me right here today.
But ultimately, this is going to be rolled out in relation to everything, isn't it? Yes. So that's crockery, it's the backdrops that we see here in this committee room, the signage around Parliament House. Does it include all of those things?
Absolutely. For anything new that's being created, then it will have the new crest. But we're not just going to sort of throw out the crockery that we've had for the last 50 years. We will continue to use it. It is excellent and appropriate and represents, and it was made at a time when that crest was in use and is a marvellous historical piece, Mr. Murphy.
How many people are working on rolling out this change? Full-time equivalent positions, for example.
in terms of full-time equivalent positions, less than one. We had some work done by a graphic designer, obviously, to actually mock up the new crest. We're working with vendors, for instance, the lifts. We have to work through the lift vendor to update the image in the lift, so we're going through and doing that. But as the President said, for most of the work that we're looking at, we're building it into existing projects. So I think the committee, for instance, knows that we, over the parliamentary recess, we're redoing the gatehouse at the front of the building. We will update the crest as a part of that project.
I mean, it's almost every area of Parliament is going to have this change at some point or another.
At some point or another, that's right. We have a project at the moment that was already on foot to look at wayfinding around the Parliament, to go to consistent and accessible signage and the rest. As we do that project, we'll update signage. We were going to update signage anyway, so we'll use the new crest at that period of time. The primary short-term work is around the digital assets. As a part of that work, we'll also look at whether there are any other parts of the building where the crest is prominent and should be updated but aren't part of a future project. And by the next estimates, I should be able to give you a sense of where we had to make those changes.
So what's the cost of updating the crown across all of these things? Have you prepared a cost?
We've been working on what it would cost to do. To give you a sense of, obviously the digital asset update was really just the work to design the crest, which was not a huge amount of money.
Well, it's more than that, isn't it? Every single person in Parliament that's using it on an email or on a digital letterhead or something else is expected to change it, aren't they?
Yes, that's true.
So what's the cost of all of that?
I haven't gone through a process of estimating the cost of that ripple effect.
Or how many hours is that likely to take?
Well, I updated my email the other day. It took me about 2 minutes to do, so I guess 2 minutes per person on that side of things.
Across the whole Parliament?
Yes, across the whole Parliament. There's about 1,200 people across the whole Parliament, so 2,400 minutes of work.
If they're all as capable as
crown out on your sign? Have you crossed the crown out on your sign, Murphy?
I have, yeah.
You have. That's why are you vandalising? Why are you vandalising the name signs?
How long is it going to take to complete this change, do you expect?
Look, the digital work will be done over the next week or two, so that'll be updated in the next couple of weeks. As the President indicated earlier, the advice we're providing to people is to not make the updates for things like letterhead, etc., until they run out of existing stock using the existing crest. Depending on how quickly people use up their stock, that could be some people will get that done the next month or so. Other people, it might be a year before they update it. Really, what we're trying to do is build it into the normal refresh cycle as much as is humanly possible. Having said that, just to go back to something I said before, one of the things we are looking at the moment is that are there any prominent examples of the crest that are not part of an upcoming period of works that we should update in the shorter term. By the time we come back at the next estimates, I should be able to tell you.
And back to the cost, are you able to take that on notice?
Yes, absolutely.
And tell me how many full-time equivalent people are on it exactly, and how many hours of work you expect this is going to take to update across
very
the
happy to,
Parliament.
Mr. Maffey.
Thank you. And is this a priority for the Parliament to use its resources in this way when we've got so many other meaningful things we should be doing?
The Parliament can walk and chew gum at the same time, and this is clearly an appropriate issue of protocol, which needs to happen. But if you're suggesting that this shouldn't be the overwhelming number one priority of the Parliament, of course you're right. That having been said...
do you think it's going to make a difference to the people of New South Wales to have an updated crown logo?
I do think it's important that the Parliament reflects the current status of who the head of state is of New South Wales. Yes.
And how long's this change going to be current for? This is only for the current monarch, is that right?
Yes.
And then there'll be a new update after that.
So hopefully for many, many years to come, Mr. Murphy.
So
King Andrew.
The question I have then is...
for money, we have to update it.
Why can't we just adopt some form of logo that doesn't require updating every time the monarch changes?
We at the moment
For example,
crest,
by removing the crown. Wouldn't that be an easy way to deal
Well,
with it?
if the Parliament was of a mind to make that recommendation, then of course we would follow what the Parliament wants to do.
So you're saying it's a matter for the Parliament to pass a resolution with that
I'm
effect?
saying that if the Parliament did pass a resolution, then obviously we would look at that. There may well be constitutional reasons, other reasons that the crest is as it is, but I generally, whenever I possibly can, follow whatever the intent of the Parliament would be.
Yeah, and who exactly makes the decision to do this? You said earlier it was what was the name of it? The executive group? Or
No,
something?
it wasn't the Parliamentary Executive Group. It went to the
Protocol?
Senior Management Group. So you may want to speak.
Yes,
I wasn't part of that decision.
yeah. So and Stephen, feel free to jump in with anything if I miss anything. So after some discussions with the protocol function in the Premier's department, a recommendation was made to the Senior Management Group to update the crest to reflect the new monarch. We considered that and approved it. And then informed the presiding officers of that decision. As the President says, now, my preference would be if both houses were to resolve to a different logo. I would hate to have two crests doing the round, so that would be complex. But assuming for a moment that both houses coordinated, the decision on what the crest is, and Stephen, please tell me if I'm wrong here, but the Parliament could resolve to have a different crest completely from what currently used.
Rather, not the State Coat of Arms, though.
No,
obviously.
yes, that's right.
There have been instances in the past, the distant past, where the Assembly and the Council had different crests.
We would not
logos.
encourage that.
And it would be very hard for Mark because which one would he choose?
Oh, well, I'd put a digital rotating crest that would flip between the two, but in the physical space, yes, that would be very, very difficult. But my understanding is that, yes, we couldn't, if we wish to incorporate the state coat of arms, for instance, they would have to be, it would have to be the state coat of arms. We couldn't make adjustments there. But in terms of the decision for the crest, to be honest, the crest in its current form has been that for well beyond my time in the Parliament. I would have to go back and have a look at what the origins of the crest in its current forms are. But my understanding, it is entirely within the will of the Parliament to make a change to the crest. And as I say, I would only ask that you consult with your colleagues in the lower house and try to come to a consistent position on it.
What happens if the monarch changes again and we're in the process of updating the crockery, for example? Does that mean you've got to scrap that process and go to a new one with a new monarch's
obviously,
crown?
if that changes, then we change it again. Full stop.
But the President referred to earlier, and I think this is important, there are artefacts that were created at a point in time which we would never change the crest on because they were created at a point in time. So crockery is a good example of that. We still have like the King George crockery in storage that was made for the visit that never happened, but we didn't go and update that when the monarch changed. So a lot of the artefacts that we have in the building we will not update because they represent the time in which they were created. But if we commission new crockery tomorrow, we would use the new crest for that new crockery. So there are a lot of artefacts around the building that we would not change because they represent a particular point in time, and we would leave them in that kind of in this form that they currently are in.
All right, thank you.
Well, can I say
You've got more
so-
chance of passing your motions than getting the crockery changed, mate.
So just to
Thank
clarify,
you.
that we're not actually compelled to change the crown. It's just at our discretion, effectively, to follow the protocol. Is there something that requires us to actually update the
my
crown?
understanding is this was done through the New South Wales Government protocol process, and that it is usual in terms
The
of
governor's going to get a new number plate.
Yeah, no,
all that kind
in
of
terms
stuff.
of the actual specific
All the
requirement, I don't know
courthouses.
the answer to that.
To be honest, I don't off the top of my
We're
head.
Probably
came from the Premier's department, mate.
Notice.
Yeah, I mean, look, it's certainly an interesting intellectual point, and we are very happy to come back with the reasoning behind it, and also the whether it's a requirement or and what the background of that is.
Yeah, I mean, obviously, if it's specific, if there's a requirement, that's one thing, but if it's at our discretion, then obviously
New
it
South
seems
Wales
like
government,
an
you have-
enormous waste of
President?
money, doesn't it?
That's your
No,
side, mate.
we're happy to provide the background for you.
I might just ask a couple of questions around security and the security of members and MPs.
Rachel, there we go.
We're obviously in a fairly heightened political environment, and the AFP Commissioner some months ago announced the establishment of a national security investigation team to deal with threats against federal parliamentarians. I know we've got the ongoing parliamentary security review. I know we've done the members' physical security survey. I'm just wondering if there's been any advice in relation to the safety of the parliamentary precinct, but the safety of MPs and members more broadly.
We have, well, frankly, over this parliamentary term, we've been getting a range of expert advice in a whole range of different areas, one of which was what you just mentioned. We're very conscious of this issue, and I'll get Mr. Webb to talk about it specifically, but I would just make a couple of points. The first is the security situation in this place is one that's constantly evolving. We will never get to a point where we say, we are now done with security in the building or in electorate offices or wherever it happens to be under the parliamentary precinct, that means we are secure. Obviously, we can never say that we will be 100% secure, but we will always do everything we can to make us as secure as possible. That's the first point. The second point is when there are issues that we can do, which are recommended to us and that can be done with speed, we will do that. One example of that, for example, is the cloaking facility, which we've just put in this year, whereby people now can't take a whole range of things into the chambers when Parliament's sitting, which was a recommendation and will increase the safety of members. But you're quite right to talk about this issue. It's something that occupies me greatly and concerns me greatly, which is why we've got a range of different strategies in practice, but I'll get Mr. Webb to speak to them.
Long-serving members of the committee will know that I'll be choosing my words quite carefully in this space. I'm always conscious that anything I say here is in the public domain, and I don't want to give any kind of a blueprint for where vulnerabilities are and the like in the Parliament. Can I just renew my general offer that if the committee wants a private briefing on security, or if any member wants a private briefing on security, I'm always available to talk through issues. But just at a high level, to the point that you made, as you say, we've been reviewing security over the last 12 months. It's taken quite a few different forms. We've sought some external expert advice. We've also been talking, as you quite rightly mentioned, directly to members, using the excellent expertise we have within the security team and with the usher and the sergeant as well as looking at what other parliaments are doing and the like. If I can give a shout out to my colleague Rob Hunter over in Western Australia, who does my job over there. They've been doing some excellent work in the security domain over the last 12 months as well. To the specific point that you mentioned, as you know, we've been looking at three dimensions, the precinct, members in the community, and then electorate officers, which obviously isn't as relevant to this committee. I think you're pointing a little bit more to the security of members when they're out and about, as well as here in the precinct, which is incredibly important. There's a couple of dimensions to it I think I can mention at a very high level. While we didn't have the specific sort of task force that was set up federally, we have renewed our channels of intelligence with various bodies to ensure that if any issues come up regarding individual members of this parliament or groups of members more generally, we have increased the intelligence flow that would come through to us to give us advance warning of that as much as possible. You would have also noticed that over time, as the security level, both generally and specifically to this parliament, goes up and down, you would have noticed at some point there are more visible special constable patrols, so we flex up and down the amount of visible security here. There's been a range of measures we've put in place over the last couple of years, some of which is individual members can choose to take up or not. That includes things like personal duress alarms. So you can, there's an app you can have on your phone, but you can also request a specific pendant-style duress alarm that you have with you when you're out and about in the community. And one of the things that I always recommend to members, if you're in a situation where you're feeling uncomfortable when you're out in public, the special constables are here at 24/7. They are always happy to get a phone call from a member who wishes to keep someone on the line while they walk between events or do anything along those lines. And so the special constables can act immediately if an issue happens. They're the sort of areas that I'm happy to talk about publicly. There are other things that we've been doing, but they're ones that I'd probably prefer not to speak about publicly at this stage.
One area that's been raised with me by some of my colleagues is the exposure they feel having meetings within the community, because we obviously don't have electorate offices, so they're often taking place in cafes or a public place, a food court. Has consideration been given to whether or not there could be a provision for the use of co-working, co-located spaces in the absence of an electorate office, whether that's an allowance or an entitlement to allow that to become more frequent?
Do you mind?
Please.
Yes, the short answer is yes, we have given consideration. Obviously, the body that needs to make that determination is the Parliamentary Remuneration Tribunal, and I would encourage any upper house member, either through their party or directly when making a submission to the PRT, to mention this issue. Of course, you'll have also access to an electoral allowance which you could use for this purpose, but we have been supportive of the idea that especially upper house members who do not have an electorate office, in particular, I know there are some members that live regionally, and so accessing their office here at Parliament House in non-sitting periods isn't practical from that point of view. So particularly in that instance, but also when people are out and about, just generally even metro-based members, that this can be an issue. We do encourage that members try to utilise things like local government offices and the like for meetings where possible, but as you quite rightly say, Mr. Namber, that there's as a member of this place, you need to meet constituents where they are, not necessarily where might be most convenient for you. And so having the range of possibilities for you available is something that we are very supportive of.
Just get yourself a caravan, mate.
Thank you. I might just ask a few questions before I hand over to Wes. I'd like to raise again an issue that I've raised previously here at these hearings, and that is the line of succession to the English Crown. Members of Parliament are required to either swear a pledge of loyalty to the people of Australia, or they can swear the oath of allegiance. And that oath of allegiance says, "I swear that I will be faithful and bear true allegiance to His Majesty King Charles, his heirs and successors, according to law, so help me God." So it's swearing allegiance, I would say, some might argue, to King Charles and his heirs and successors. Those heirs and successors run into many thousands of people. Apparently at the end of the line is a German physiotherapist who had no idea that he was 5,716th in that line of successors. The 13A of the Constitution Act in New South Wales said a disqualification from being a Member of Parliament was takes any oath or makes any declaration or acknowledgement of allegiance, obedience or adherence to any foreign prince or power. How is it that the oath of allegiance is swearing the oath of allegiance does not disqualify you from Parliament under the Constitution Act?
Sorry, just repeat the question.
How is it that swearing if one was to swear the oath of allegiance, you are not disqualified from Parliament in doing so under the 13A of the Constitution Act?
Look, I would refer to the answer that I gave in the last budget estimates on a broad sense, but in terms of the specific constitutional issue that you've raised, I might throw to Mr. Reynolds, who
The look on his face.
who can address this matter in more detail.
I'll refer to the answer to the question taken on notice, which says, I refer the Honourable Member to the interjection by the Honourable Chris Rath and to Section 12.4 of the Constitution Act 1902. Mr. Rath's interjection was that the King is also the King of Australia. Section 3 of the Constitution Act defines the legislature as His Majesty the King with the advice and consent of the Legislative Council and Legislative Assembly.
Yes, but I'm not talking about the King of Australia. I'm talking about his heirs and successors. You've sworn allegiance not only to King Charles, his heirs and successors. So in swearing allegiance, you've sworn allegiance to the King of Australia, but you've also sworn allegiance to all his heirs and successors concurrently. Have you not?
Well, that would appear to be the reading of that particular line, sure.
And so therefore aren't you then disqualified? And some of those people, many of those people are literally foreign princes. Are you therefore not disqualified from Parliament?
Because
You've sworn allegiance
to a foreign power.
to a foreign prince.
To the successors of the crown, though, they're not. They are in line, but they are not. They don't succeed the king until they become the king or queen.
Yes, I think
But-
that
Yeah,
that's...
but they don't. Again, they don't become the
Point
king
of
until
order.
it's a ridiculous point.
It's not. It's an interesting intellectual point.
Well-
Mr.
Well,
Buckingham.
I don't know if
if
that's
that's
well.
the
We've just
description.
found. We've just
Could be
found
the
out
game,
that parts of this
well,
New South Wales
whatever.
Constitution Act were in fact invalid.
Kicked out to
So
some
it's
king.
something. There's parts of this act that haven't been scrutinised.
Sure.
Has the Parliament received legal advice about the constitutionality of the oath of allegiance?
No, I think I can comfortably say that we haven't. Nonetheless,
Because
to treat this seriously,
Yeah.
I understand the point, and it is. I think that for obvious reasons, there is a far greater focus on the line of succession of the monarchy at the moment, and I think therefore these questions are of value to consider. Clearly, we're not going to provide specific, deep advice about the Constitution in this hearing, but what we will do is treat the question seriously, take it on notice, and come back with an actual substantive response.
See the interjection of.
Thank you very much.
You're
Mr.
welcome, Mr.
President.
Buckingham.
Mr. Fang,
Oh, no more questions, Chair?
that's me.
Oh, okay. Well, maybe I'm the only one that's done any work around here. Mr. President,
Order.
we were talking about
Yes.
the Cullen versus President case, and of course that's not the only issue
It's not.
where we have been bled dry from our legal contracts. There is another one, isn't there?
There is.
What could you perhaps provide a little bit of background in terms of the other mess that we have been trawled through?
Sure. So I presume the issue that you're talking about is the case of DPP versus President of the Legislative Council.
It is, unless there's something else, in which
No,
case
no,
I am all ears.
I'm very hopeful that they're the only two currently. So I will give you some detailed background about this. So in October last year, Portfolio Committee number 5, which is the one focused on justice communities. I'm not sure, are you on that committee, Mr.?
Not yet.
Must
but
be
let's
one
just
of you
see.
indeed, one of the
I
only
think
ones.
I am now.
Anyway, it commenced an inquiry into identity protections for proceedings involving children, and which I assume is what you were foreshadowing before in the
Yes,
previous
that's
answer.
exactly what. Yes.
So as a part of that inquiry, the committee published a redacted submission made by Judge Wass, SC, which was highly critical of the Department of Public Prosecutions. In later proceedings in the District Court before Justice Wass, the DPP then argued for the judge to recuse herself on the basis that the submission indicated apprehended bias against the DPP. So on the 15th of December last year, at the request of Portfolio Committee number 5, I referred the director of the DPP to the Privileges Committee for a possible contempt on the basis that the use of the submission in court proceedings was a breach of Article 9 of the Bill of Rights, obviously the one referring to parliamentary privilege. Then on the same day, the DPP commenced proceedings in the New South Wales Court of Appeal against me as President of the Legislative Council.
And we have a great run there, don't we?
Yeah, in the Director of Public Prosecutions versus President of the Legislative Council of New South Wales. Subsequently, the New South Wales Attorney General has joined proceedings in support of the DPP. And as of the 5th of February, the Commonwealth Attorney General has also joined as a party.
And what position is the Commonwealth DPP?
We'll get
Oh,
there.
okay, we're getting there. Don't
So
run the
it's traditionally been considered settled law that a published submission of a committee is a proceeding in Parliament within the meaning of Article 9, and therefore it can't be impeached or questioned in a court, i.e. that parliamentary privilege applies. However, the applicant, the Office of the DPP, in their submission lodged on the 20th of January, argued that Article 9 of the Bill of Rights 1689 is either to be interpreted in a manner that allows the submission of WASJ to be used in the application for accusal, or alternatively, i.e. Going against what the tradition that we have long held to, or alternatively that Article 9 is invalid based on the ever-present cable document.
Yes.
My submission was lodged on the 9th of February, and in that submission, I confirmed that the House's position. That the construction of Article 9 does retain its broader meaning in terms of parliamentary privilege, and as a matter of constitutional law informed by the principle in cable, then the director would not be precluded from relying on Judge Wass's submission for the purpose of making a recusal application on the basis of apprehended bias. So where to from here? Hearings are scheduled for the 24th and the 25th. Well, my apologies, they happened on the 24th and 25th of February. We were represented by Brett Walker SC, Mr Tom Wood and Ms Frances Leach. The position has been reserved, and we are awaiting the outcome now. Mr Reynolds, do you have anything else that you want to add to that?
No, only that the last point you made, that we're awaiting the judgment, so we probably don't want to talk in public too much about any legal arguments that have been presented at the 2 days of hearings we had last week.
It's interesting that you make that point, because I guess in part the argument is that, the accepted position has been previously that these proceedings that we are currently in now would have been covered by parliamentary privilege, correct? Yet now, I guess part of the position is that parliamentary privilege won't apply to matters that where a court may wish to raise matters that are said in the Parliament as evidence.
No, that's not the argument about cable. And as I said, I want to be very careful not to. The argument put in the submissions by Mr. President is that only for the purposes of a recusal application for apprehended bias by a judge would parliamentary privilege be
Not
lifted
applicable.
to that very, very narrow extent. It would have whatever the decision of the court, it will have absolutely no effect on proceedings like what we're having now.
So you couldn't have a situation where the court, needing to make a determination about a matter that relates to itself, effectively, where we're seeking to recuse a judge, the judiciary is effectively seeking to make a judgment about itself with evidence from the Parliament. We're saying that because of the cable principle, the court can do that, but nobody else can.
Correct. I think what you're saying is correct. That's the position that has been put in the hearings last week.
Okay, so would that extend then to suggest that a contempt of court could be determined using parliamentary privilege because the court is determining its own matters?
I think that's not really a point that's being argued at the moment, so don't really have a view on that.
I guess what I'm getting to is how we've got a situation now where two departments from the government, one the Premier's own office and now the DPP, are seeking to erode the long-standing principles of this parliament in a single term of government. It's extraordinary, and it's never occurred in the 100+ years of federation, and certainly the 200 years that this parliament has existed. How is it that we're continuing to see the parliament's powers eroded by these continual challenges by the New South Wales government itself?
So I might address that.
Mr. President, that might be one more for you than the clerk.
So the short answer is I'm obviously not going to address that political issue.
It's a shame. I was really inviting you to, but I understand.
But what I would say is I would disagree with the contention in terms of the Cullen matter, because the outcome from the Court of Appeal was that this piece of legislation is invalid, or Section 7 to 9 of this piece of legislation are invalid. So rather than there being any sort of ideological bent there, that is where it currently is. Now, that may be changed, that may be reversed with the appeal if our appeal to seek leave is successful, and then if we're successful. But at the moment, rather than it being that issue, that specific one, being an ideological issue, it's in fact now a legal issue. So that's the only point that I would make. In terms of your broader contention, that's a political issue that I'm sure will play out in a range of other forums down the line.
Okay. I guess, given that we've had a number of challenges to the powers of this House, and that we've seen the eroding of what were long-standing principles, and indicating, as you did, that you would seek a legislative change, given that you haven't raised the issue of the opposition's bill, what work have you done as President to ensure that the powers of the House are returned, so that we're not sitting ducks or, effectively powerless to encourage witnesses where required until the indicated timeline as you gave, which is the end of the year, where we have a resolution in relation to the appeal?
Well, I've done two things. The first is that I've obviously, after determining the view of the House, that ensured that we are seeking leave to appeal. So that's the first point. The second point is I don't think I could have been louder or clearer on the fact that I think that there should be a legislative solution. As I mentioned to you before, I'm fairly ambivalent about what solution that takes, what specific solution that takes, so long as it addresses the issue. Yeah. At the end of the day, though, Mr. Fang, I'm a servant of the House, and I am required to and incredibly committed to enacting the view of the House. But insofar as the position of President is respected in both this place and more broadly, I've made it clear that my view is that there should be a legislative solution achieved on this matter as a matter of priority and urgency. Yeah. And I don't know that I could have been clearer about that.
It's fair to say that the Court of Appeal's decision not only impacted the Legislative Council, but it's had an impact also on the Legislative Assembly. Is that correct?
Absolutely.
Okay. So I guess in terms of the impacts that it's having across the Parliament, have you had discussions with the Speaker and conversations with, I'm not sure if it's PEG that would manage this, but certainly whether the clerks have had conversations between the houses as to how we resolve this matter so that whatever situation is implemented is restoring the power of effectively both houses, not just us looking after ourselves.
Yeah. Well, I mean, the short answer is there has to be political will. The Parliament needs to land in a position where a majority of its members determine that they want to solve this issue and they want to resolve it. The bill that you referred to previously is one potential way to do that. There are others, I'm sure, but that's the one that's before the Parliament at the moment, and that's the one that'll be considered.
Okay.
But there are no doubt other potential options. My encouragement of all members of Parliament is, whether it's through this bill or through other forums, whether there be an inquiry, whether other legislation is proposed, that people work in good faith and appropriately to protect and preserve the position of the Legislative Council and the Legislative Assembly, this Parliament in toto, to be able to ensure that the inquiry system and all of its broad functions are able to be continued as they have been for the last 125 years.
Mr Fang, there's also, of course, the inquiry by the Privileges Committee into the Parliamentary Evidence Act, which I know has been put on hold because of all the other inquiries the Privileges Committee has before it, but that could also be a vehicle for some interaction with the other House in terms of their Privileges Committee if the Legislative Council Privileges Committee with its inquiry could engage with its counterpart on this issue.
I note that in answering the question, you've referenced a number of times that the bill is one of the ways with which we may achieve that outcome. Has there been any other approaches by the government or the crossbench or even the Legislative Assembly in relation to finding a resolution and work? Has anyone else indicated that they're prepared to work to resolve this matter? I would have hoped that the government would be clambering to bring their own bill forward, but it seems to be that that's not the case. So what are the other options that are on the table, Mr President?
Well, I mean, again, this is the Parliament is the master of its own destiny, so it's really up to the Parliament to determine. But certainly, if one reads the judgment of Cullen versus the President, we see that there are references to some other jurisdictions, which I think are always worthy of considering and looking at.
Yep.
There are other options, but it's not for me to propose them. It's for me to enact them once the Parliament has determined which way it wants to go.
Well, I think you're being a little bit modest there, Mr President. You're certainly one of the two presiding officers with carriage of the Parliament, and I guess as you indicated in your, I think it was 29th of December, your communication in relation to the matter of the appeal. Obviously, you've indicated that you have a role, I think, in ensuring that a resolution is found and quickly. So I guess to those ends, being the leader that you are, you would be seeking to bring forward a response so that the Legislative Council can once again retain its full powers. I assume you've done some work on that. And
look, I guess I just repeat what I said before, which is that I loudly, unequivocally declare today and broadly that I will happily speak to anyone about this matter, that a legislative response should be found, and that I hope that members on all sides will be amenable to doing that. But, Mr Fang, I'm absolutely happy to speak to any member about this and make my views on these matters known.
So I think it would be fair to say that any legislative change would require, I guess, a bill of both houses, to go through both houses. And in those circumstances, the we are very clear about the numbers in our house. We deal with it every day. But in the Legislative Assembly, obviously, the government is a minority government, but it has, I would say, the ability to, with the opposition certainly seeking to have this resolved quickly, it would be the government that would be the stumbling block in relation to that. So where that's the case, and if the bill that's before the House isn't suitable to the government, have you approached the Premier to ask as to what solution the government might be prepared to bring to the table in order to resolve it?
No, I haven't. I mean, I know that as you rightly say, the opposition is clearly focused on this. The Leader of the Opposition in the Upper House brought in the bill. And I would hope that there are conversations between the government and the opposition about this matter because of its obvious import to the Parliament. If we're in a position, for example, where this bill doesn't get passed, then obviously I hope that there will be further continuing conversations, and I'm very happy to be a part of those conversations. But my hope is that all members understand that this is a very serious, very significant, very important issue that goes to the fundamental powers of this place, and that the potential to compel witnesses to attend an inquiry is an absolutely fundamental part of this Parliament being able to operate, in my view, most effectively. So that will continue to be my position.
Okay. So it's fair to say then there's only really one resolution that's currently been proposed. Is that a fair assumption, or are you aware of
well, in
others?
terms of addressing this issue, I think there are two. The first is obviously the bill that's been proposed. I don't know of any other. And the second, of course, is the potential appeal in the High Court. I don't know if there's any other legislation that's been proposed. No.
Okay, so
no specific inquiry other than the Privileges Committee.
Well, yeah, the Privileges Committee inquiry predates all of this, but it is specifically into the Parliamentary Evidence Act.
okay.
And so potentially there's an opportunity there, particularly, if this bill isn't successful, or frankly, if as it goes through the, through the process through the houses. But I would encourage, the Privileges Committee to consider this issue, and I hope that the Legislative Assembly is considering this issue as well.
So I've just brought up your statement from the 29th of December, and it says, instead, as the President of the Legislative Council, I intend to work with members from across the political spectrum to develop an appropriate legislative response to this matter. So where it says that you're intending to work with members to develop an appropriate legislative response, do you see that it may be the case that you can be the leader on this and actually...
Yeah, look, obviously that statement was put out in the context of following the legal advice and looking to a legislative appeal, a legislative solution rather than a judicial appeal.
They're not mutually exclusive, though,
No, they're not mutually exclusive, but I'm just saying that obviously the circumstance changed, and I had hoped that could have been addressed through that, and I'm still very hopeful that it can. But as I said before, I remain very committed to this issue, and I'm very happy to talk to anyone at any time about how this issue can be progressed.
Thank you.
Thank you, Mr. President. The government, Mr. Bob Namber.
Yeah.
Oh, sorry, Mr.
Just following on
Deanne.
from that.
We're all going to turn.
So is it fair to say that if a legislative solution is arrived at, that the application to the High Court would just fall away, that there would be no point, would there?
Well, I don't think it just automatically falls away. Mr. Reynolds might have a view. We would need to withdraw it.
Yeah, it would be a decision that we'd have to make in consultation with both our legal team and, of course, with the members of the Legislative Council.
Would there be any logic in pursuing the case if there was a legislative solution arrived at?
Well, no. Well, my view would be if a legislative solution is arrived at that deals with the sort of issues that we've just been discussing, the reason why we've appealed the decision is to try to to say that we disagree with the striking down of section 7 to 9. So there would be a lot of good sense in then, if that were the case, withdrawing the application. But as the clerk rightly points out, we'd obviously need to speak to our legal team and to members and so forth about that. But that makes sense.
And if we withdrew the case, then the council would still then have to
Would you
bear
mind
the
just
costs.
pulling your microphone?
Sorry, if we withdrew the case, the council would then have to bear the costs. Is that right, of the Cullen decision?
If we withdrew the case, I'm sure we'd still be liable for the cost to date of the other side that we're liable for under the initial judgment. But of course, the appeal is based on the validity of Section 7 to 9 of the Parliamentary Evidence Act. So, if a legislative change had happened that that changed those provisions, there'd possibly be nothing to be appealing. The legislation would have made the appeal redundant.
So what would be? So have the Cullen costs been quantified?
We've taken on notice what we have paid to date, but we haven't been given a figure of what.
So we don't know what the
are.
Cullen side.
All we know is that we're responsible for. I think it's between 60 to 70% of their actual costs.
But you don't know. You have
We
no
haven't
estimation of what that quantum
We haven't been
is.
told that yet. No.
Right. Thank you.
Mr. Namber.
Thank you, Chair. If I could just turn to the member staff condition survey and the associated town hall presentations that went with that. What were the outstanding and significant areas of concern that were raised through the survey and following the town hall meetings?
Just give me one moment. The major themes that were raised included staff resources, role descriptions, allowances, remuneration, and potentially a different classification structure. They were the five major themes that came out of the survey. And I should make the point that about 20% of the members' staff responded to that survey, and about approximately 10% of the LA and LC members responded to the survey. In terms of the town hall, there were a range of different issues, but I think in terms of the broader thematics, they fell into those major themes.
Given the concerns that have been raised previously around getting a sufficient cross-section of staff to respond, I think was it out of the Bent and Edwards processes, is that are you confident that's a satisfactory cross-section?
Mr. Webb might have other comments about this, but I feel confident. I feel comfortable now that the consultation process has certainly been significant and substantial, and thorough, but I do think it's been effective, and I, for one, feel like we have now a very good understanding of what expectations are from staff and more broadly, and that we're in a position now to draw a line under the consultation phase. But Mr. Webb might have some other comments to make.
Yeah, that is a really good point that you make, Mr. Nanva. One of our concerns in previous consultations was, as you say, the scope of whether people had the opportunity to participate, and we were feeling we were getting information from a relatively narrow and not representative group. Even though the 20% figure obviously, I would have loved it to be 40% or higher, but we are now convinced that we've had enough mechanisms and enough opportunities that anybody who wants to have a say has had a say. The previous concern that was raised with us and the concern that we had was that there might be people there that had wanted to have a say but had not had the opportunity to do so, and because the results were relatively from a narrow group of people, we were just concerned that we had not picked up all the issues. We're now convinced that through the consultations we have, that anyone who wants to say something has said it, and that gives us the fantastic point in which we can take the next steps. So.
For example, after the survey, you might be aware that we then organised a town hall meeting, which could be attended either physically or virtually. We got some feedback that there wasn't enough notice, and it would have been terrific to have a little bit more notice of that. So we didn't just cancel that one. We had that one, but then we organised another one later to ensure that everybody was able to participate. We've always tried to be as open and flexible as we can to allow anyone who wants to provide feedback the opportunity to do so.
Okay. Those areas around role description, classifications and remuneration are a pretty persistent theme, not just in this survey, but consultation prior to that. I might come to those in a second. Just with respect to, I suppose, actioning the staff condition survey results, what are the next steps in that, and how will that inform what takes place in the next steps of the MOP's financial strategic plan?
So obviously this is, clearly this issue requires resourcing. So we are now at the point whereby we are formally engaging with the government about the how to land this issue and how to progress, but I'm committed to doing all I can to working out the best way to achieve a good outcome for the staff, and the money doesn't come from nowhere. That comes from the government, and so I've already started negotiations and discussions with the Treasurer.
Just on the resourcing, you're right to say that everything like this has a pretty significant cost implication, and you can't will up money from nowhere. So I accept all that. I guess the issue around job descriptions and classifications isn't just about the money. So I suppose what I wanted to put to you is that becomes a concern, obviously, when you have those job descriptions and capabilities and duties and structures benchmarked against the Public Service Commission templates. Can we decouple the job description rewriting from remuneration? Because for a lot of staff, it's not just about its link to being better remunerated. It's about being able to leverage the non-financial benefits of more substantial and realistic job descriptions in a post-parliamentary career, whether that's in the private or public sectors. And at the moment, we have a pretty unrealistic set of job descriptions, and it's very difficult for staff to leverage those in alternative work environments.
Yeah. You should be a union rep.
So I guess what I'm asking is, I accept the financial implications that come with a project of this scale, but is it possible to decouple the two, not worry so much around the benchmarking of new job descriptions with the Public Service Commission templates and then the remuneration that comes with that, but focus more on the job descriptions and classifications in the first instance, so that staff can actually leverage those for non-financial benefits?
All right, a very good question. I'll throw to Mr. Webb to make some specific comments, but I'll just make a couple of broader contextual comments. The first is that you would be aware that we put out a determination which was based, I think probably a year and a half ago now, a year ago, which was based on the non-financial issues, which has sought to address a range of different things. One of which, for example, was we changed the name of the
title of the...
the title from research assistant to advisor and so on.
Yep.
And there are a range of other things which I can go through if you'd like me to. But my point, I guess, is that we are always open to doing anything that we can that assists staff in the determination that we put out. That is something that is useful and worthwhile. We put out that determination, then we gave an opportunity for feedback and for a few bits and pieces then were changed because of the feedback that we received. That is an ongoing living document. So people shouldn't feel that it's only when there is a formal consultation period or a formal review period that they can come back and provide their views about it. I'm not saying that those views will be enacted immediately, but I don't want people to feel as though they're restrained from talking to us about the determination at any point, particularly on issues that don't have a financial impact. So they're just framing comments before I then throw to Mr. Webb.
Yeah, I was going to mention the same, that we've got the non-financial opportunities through the presiding officer's determination around conditions of employment, of course. You raise a really interesting point. Theoretically, I agree that the description of, you could separate out the remuneration from the description of the work. But as you know, from an industrial point of view, those two things are quite intimately linked. Many years ago, before either of us were in this place, Mr. Adam and I used to face off about the Crown Employees Award and the various conditions therein. You'll be shocked to hear that he was on the union side of that discussion and I was on the government side of that discussion. But the very close link between the way a job is described and the remuneration attached to it in an industrial sense is something that we're very aware of. So what we've tried to do is do things like change the title, as you mentioned, Mr. President. We've tried to put in things like the description of what's reasonable hours under the all incidents of employment allowance, and put in place a time off in lieu regime for hours that go beyond that and the like. We have stopped short of redescribing roles because of the potential link to remuneration. You're absolutely correct, but I'm very open to an idea that we might be able to find something we can do in that space that doesn't trigger the industrial remuneration side of things, but provides a little bit more contemporary description of the way that people work.
I mean, there are a range of steps involved in a sort of root and branch review of this scale.
Yeah.
I mean, the first step is obviously job descriptions that marry up with the roles that are actually being performed.
Yes.
I accept what you're saying about the HR implications and, job descriptions and then classification structures being inextricably linked with remuneration, which then causes the funding model problems downstream. But that only becomes an imperative once they are benchmarked, which is, a few steps down the track.
Yeah.
I just don't know what the impediment would be to reviewing the job descriptions in the first instance as a preliminary step.
Yeah, so the kind of thing I'm thinking of is the potential to give effect to that, but as a way of putting some descriptive stuff around the existing job descriptions that might give effect to what you're saying without triggering because until we've had the negotiations with government around cost, I want to be very careful that we don't cruel any pictures, because we absolutely want to get an outcome from this process.
You get to the pointy end of the benchmarking.
Yes, that's exactly right. So I am very open to the idea that we look into some way of achieving the outcome that you're looking at. I would just want to make sure that we don't do anything that would stop the progress with government around the funding side of things, but anything short of that I'm open to, yeah.
Because I just think it'd be, we're all conscious of the financial impacts, but there are a range of non-financial benefits that staff in particular can leverage in the public and private sectors if they've got job descriptions that actually reflect the substantive roles that they play for members.
Yeah.
And the other difficulty I've had with it is that, MPs and members provide different roles from office to office. So
Yes.
having a fairly standardised template
Yeah.
that doesn't take into consideration the vastly different roles that we expect our staff to play is just inherently unfair on the staff as well.
Yeah, philosophically, what we're looking at with when we get to that sharper end, as you say, is looking at role descriptions that essentially says, here's the broad range of things someone in this role may be required to do, but the specific things that you personally might be required to do depends on which part of this does your member need you to do. So trying to find a way of giving that more expansive description, but also acknowledging that not everyone could do it. Not everyone is expected to do everything that could potentially be done by either an elected officer or an advisor in the upper house, but finding a way that gives that kind of flexibility going back and forth. I think there are things, in the lead up to the last election, a couple of members asked me for assistance in translating the work of a member into language that would make sense in the private sector or not-for-profit sector, because the straight out description of what a member of parliament does not always translate into the world outside of this place. And so I did a little bit of work with some individual members to do that translation process, to sort of talk about, for instance, the community liaison part of being a member, the engagement with community. How do you describe that in terms that the not-for-profit or private sector would kind of understand? And so there's a potential for us to do something similar here in working through, as you say, something that describes the jobs, doesn't trigger the sharp end stuff until we're ready to trigger it, but describes the job in a way that people outside of the parliamentary environment will see the underlying skills and capabilities that somebody that works in an office can bring to bear.
So you're touching on a point that I was going to ask, just so I understand this right. When you're looking at this new framework, will you be looking at sort of developing a pot of capabilities and skills, and ostensibly the members would then cherry pick those that are most applicable to them?
That's exactly
and
right.
that would form the basis of the individual's job description.
That's exactly right. So one of the things that, as you pointed out, one of the things that came out of all the consultation has been the sheer variety in tasks that people have to undertake depending on what their member needs. Opposition, government, backbench, front bench, all of those kind of dimensions can fundamentally shift the requirements people have of their staff. And so it became pretty clear, pretty obviously, that we couldn't do some kind of cookie cutter position description that says, here are the three things you do, and every single staffer will do those three things. We needed to find a way to say, here's the broad range of things that you might be required to do, and then what we'll be looking at is a member then sitting down with a new staffer and saying, okay, out of that broad range of things you might be required to do, the things that I need you to do are this, this, and this, and sort of describe the job in that kind of way. One of the things we will want to talk, once we've got through the negotiations that the President's talking about, exactly what form that narrowing takes is a really interesting one. Is it a formal process where you document the subset that applies to a particular role? Is it more of an ongoing conversation between, because my understanding from talking to both staff and members is that sometimes these roles also evolve over time, so it's not like a set in stone. If you happen to be working on a major piece of legislation, you might require somebody to be right in the depths of research for that, but then a month later you might be requiring them to do more community liaison or something along those lines. So we want to try and make sure that we provide the flexibility that officers need to work effectively, but also provide certainty to staff about what's actually required of them. Because if we just said, here's a broad range of things that you can do, well, that doesn't give you any certainty about what you should be doing. So we're trying to find a balance between saying, this is what you could do, your member will work with you on what you are required to do, and then work with you all to say, what's the best way of that process coming to a conclusion.
I mean, so can you take on notice how and when we might be able to look at decoupling that process?
Absolutely.
From the broader issue of then benchmarking roles and then funding, an increase in remuneration.
Yeah,
That'd be
happy to
useful.
do that. I just even thinking it through as we've been talking, I think there's a couple of things that we could do in that space. So I'll definitely do that. And just for the benefit of the committee, something that I mentioned at a previous hearing that might be useful now. So I think I mentioned at a previous hearing that I was seeking from the Parliamentary Remuneration Tribunal some flexibility in my ability to support members who are going through transitions of staff to have overlap. The previous very strict interpretation of the Remuneration Tribunal's determination was that if you get one staff, then if that person finishes on a Friday, you can't have the new person start till the Monday because you can't have two staff at any given time. I'm pleased to say that the tribunal did grant that flexibility, so I now have the capacity to also, if you have a staff member that's leaving and a new person starting, you can come to me and say, hey, I'd like to have a few days or a week of overlap so that the new person can be trained by the previous person. That kind of operational smoothing out. I think I mentioned at a previous inquiry that part of my argument about that was the smooth operating of your offices. Part of my argument was a work health and safety argument. You get a new person who's just thrown into the deep end on day one with no capacity to learn from their predecessor. That has a work health and safety impact as well. So
I do have some follow-up questions on that if there's time. So
I thought you were about to break into
There
smooth
will be
operator.
time. There will
Like,
be
you know.
time. Just for your information, Ms Boyd, the committee resolved to allocate equal time between government, opposition and crossbench. I've only asked a few very pithy questions.
and pertinent.
Created a constitutional crisis. But apart
It's
from
been
that,
averted,
there's
you'll be
plenty
delighted.
of time for the crossbench, including right now, up until the break, and then some more time afterwards. So you've got 10 minutes now.
Great, thank you.
Hello, Ms Boyd.
And good
Use it
morning. So let me start with something that I have talked about a lot in past legislature estimates, and that's in relation to security passes and lobbyists and supported or sponsored passes. I note that our Lord and Saviour Albanese has announced some sort of a directive today in the federal parliament. Where are we at with tightening up our sponsored passes?
So I will throw to Mr Webb, obviously, to speak about this in depth, but we have already undergone a significant tightening of security passes. So we did a full review of all passes. A number of them were then either cancelled or deleted. For many passes, they were able to access the building 24/7, including on weekends. We've pulled that back for a range of people to only being on weekdays and from 7 to 7, I understand.
That's correct.
And so we're aware of the issue. It's a very valid issue. We're already starting to look at that in a genuine way. I'll get Mr Webb to speak further to that, but I understand you've got a specific issue in terms of lobbyists and so on. But I would make one other point before we go to Mr Webb, and that is this, that when somebody, and this isn't exactly what you're talking about, but it is similar, when someone accesses the building, particularly the secure areas of the building, as a guest of a member, it is not acceptable for the member then to allow them to go roaming in the corridors and to speak to other members of parliament, literally to stop them in the corridors, to knock on their doors and to try to lobby them and advocate to them in their own personal office space. And so we have put out some communication about that towards the end of last year, if I remember correctly, when it was quite an issue. I just would ask all members to be really conscious of that while one member may have a guest who they would be comfortable about them advocating to other people, think about what it would be like in reverse. And everybody must, in this very unique, as we've discussed on numerous occasions, work environment that we find ourselves, everyone needs to be very conscious of that. And to be honest, if we find that people are doing that, particularly people with passes that are in effect lobbyists or have other roles, and they are going uninvited to members' office or trying to ambush potentially members, then we will look very seriously at cancelling those passes with speed. So I just make those preliminary comments, but Mr. Webb might have some other comments.
Just for Mr. Webb, you respond there. I think there's those two issues. There's the issue of having people who are not members of Parliament or staff within the precinct being able to access because they've had somebody simply just sign a form. So there's those kind of security issues around that, and we've talked about that before, and including sort of people coming into your office unannounced. But then there's also the transparency issue over who is letting these people in, who is signing these forms. And I'm very interested in that as well. And I note that in the announcement at a federal level today, there was talk about transparency over sponsorship. So,
speaking of transparency, I haven't seen that announcement, but I will, in the break, in 6 minutes' times, get my excellent staff to find all of that information for me so that we may be able to continue this in a more deep way. But nonetheless, Mr. Webb.
So I won't repeat anything the President went through and things we've talked about previously. I might just focus on the things that have changed since we last spoke on things. So I think last time we were talking, I indicated that I was going to review the access form to make sure that there was very clear conditions and the terms of use of a authorised visitor pass. So we've done that and deployed a new form. We've got a little bit of feedback, and so I'm looking to potentially make a further change to this form based on the feedback we've received. But you can see in the terms and conditions for access to parliamentary precincts, and sadly for the first time in estimates I am now having to put reading glasses on to read things, which is an indication of how long I've been doing this. But authorised visitors will only be admitted to restricted areas of the building, including ministers and members' office, by prior appointment with a minister and member, and authorised visitors cannot sign in visitors to the building. So one of the things that we did was make sure that all of those authorised visitor passes really only get you into the public areas of the building. You can you cannot go into the tower block, but as you quite rightly say, the issue that we've had is that people will sometimes just swipe someone through, or they'll get tailgated through. But by tightening up the conditions on the pass, and everyone has to reapply for their pass every year for the authorised visitors. So that means over the last 6 months, about half the people have renewed with these new, more clearly articulated conditions. It just makes it a little more capable for us to act quickly, as the President says, when somebody breaches that term. The further update that I'm looking to make is that the consequence of that statement is meant to be clear that you can't just wander around the building. I'd like to make that more explicit in the terms of, so not just say you're only in the authorised places if you're invited to, but also explicitly say you are not to linger in the authorised spaces when you have finished that meeting. Just to be, that is the implication of what we've written, but I'd like to be a little bit more explicit about it. But I believe the terms and conditions are now at a point where we could take the kind of action that the President's talking about.
Yeah, and I refer to I've now found the email that we sent out in September last year, where we say when visiting another member or another non-public area, ensure that you or your staff escort visitors to the next location. The receiving office then assumes responsibility for escorting the visitor back to the non-public exit point at the conclusion of their meeting.
And how are you controlling for former members who are now lobbyists or working for industry or lobby groups?
Yeah, so this is the interesting part that we're now looking at. So I think we've talked in the past about the idea that there are, at the moment we just have the blanket authorised visitor pass. Former members are listed as a slightly different category, but you're quite right in saying if you had a former member who was also, say, a lobbyist, at the moment our process doesn't pick up on that at all. And indeed the authorised visitor category is still quite a broad category. So our first focus, as the President said, was on reducing access to all authorised visitors, working through those kinds of things. Now, one of the things that we're looking about as we continue to review security is whether moving to categories of passes. So having things like, do we have a lobbyist pass versus a public servant, like many of the authorised visitors are senior public servants, for instance, the police commissioner or the secretary of the Premier's department. So having different categories so that we can be more transparent in who's got what and where.
So what about, so when I've got a visitor visiting me and they have a visitor pass, it says very clearly A. Boyd on it.
Yeah.
Has there been thought given to, if you are, an authorised visitor, or if you've basically got a sponsored pass, that sponsored pass has to say the name of the member who sponsored you?
I've not thought of
I've not
about
thought of that either.
No.
I'm not opposed to that as an idea. I think that's a really interesting idea, but let's look at that. I mean, obviously, we'll think about if there are unintended consequences, but to me, that seems like an instinctively attractive idea.
Thank you.
I hadn't thought of that one.
Can I ask you where the appointment of the independent complaints officer is up to?
You can. I will throw to Stephen on this shortly. It's mildly challenging. So, as you know, the term of Rose Webb was extended for 3 months, but has come to a conclusion. We've gone to two different appointment processes, both of which did not result in an appointment actually happening. The first, who withdrew from his name from consideration after a recommendation from the two clerks, after having met with, if I remember correctly, the Privileges Committee. The second, who wasn't progressed with once it became apparent in public commentary that there was potential interest from a political party for that person to be a candidate, which is fine, but obviously therefore not an appropriate person to be the independent complaints officer. So where we are now is that we're now going to start the process again, but the Legislative Assembly in the last session moved a motion through to have a temporary, to authorise the potential of having a temporary ICO. It's my intention that we would do a similar thing in the LC straight away. We've obviously been in discussions with the LA about this. We want this to be consistent between both houses for obvious reasons. It makes things much easier. So that at least then we have the opportunity to appoint someone on a temporary basis because as you understand, Ms. Boyd, this is a very important role, but it is a challenging role to find a person who is embraced and agreed upon throughout the entire parliamentary precinct as being able to fulfil their job appropriately. But Mr. Reynolds may have some more comments to make on that?
Not really. I think Mr. President said everything that I'd say. The resolution that the Assembly passed is to allow a 12-month interim appointment to be made, which if our House agrees to something similar, it'll allow us to move fairly quickly and identify someone that can be appointed for a short period of time to cover over till the after the election, and then we can conduct probably a full recruitment again. Given the two recruitments to date have been unproductive, we want to resolve this quickly because we realise we just can't keep this position vacant for as long as it has been. I will say that anyone who has lodged a complaint in this interim period, while there's been no ICO, those complaints have been collected and recorded by a senior officer in DPS, and they will be treated when an appointment is made as if they were active at the time that the appointment was made. So
presumably the previous ones as well, 'cause I believe there were some outstanding ones.
Yeah, I understand there's one outstanding one that hadn't been completed when Rose Webb's term ended.
Thank you, Mr. Reynolds. The time being 11:03, we are 3 minutes into our play lunch, so we will reconvene at 11:15 with another 10 minutes from the crossbench before we go.
How many poppers am I getting?
Excellent.
Poppers, you're getting none. You've had your Reconvening, the time being 11:15. We will recommence with another 10 minutes of questions from the crossbench. Ms Boyd, before we will turn to questions from the opposition. Ms Boyd.
Thank you. Okay, here's something different.
Is it?
Yeah, workers' compensation.
Okay.
So the DPS annual report states that from the 2nd of July 25, new workers' compensation claims will be managed by the iCare Specialised Claims Division. EML would retain existing open workers' compensation case management until these transition to iCare. What was the basis for that transfer? And was it initiated by iCare or by DPS?
Might pass to Mark on that issue.
The arrangements that we've made were in line with just a general review of where these matters should be managed. I don't have any details on me as to the specific rationale, but I'm sure my crack squad back in the office will be sending me through a couple of details that I'll be able to give you,
Thank you.
Relatively quickly.
The iCare Specialised Claims Division is typically reserved for the most complex workers' compensation claims across the nominal insurer and TMF claims portfolios. So I guess the question then is, are these claims from DPS uniquely difficult?
I mean, we have a unique workplace, there's no doubt about that. So there are dimensions of working in a parliamentary environment that are unique and would require an understanding of what are sometimes quite complex employment arrangements. The difference between, say, the manner in which member staff are employed versus parliamentary officers, parliamentary staff, etc. So yes, I think there is a degree of complexity. We often, when engaging with executive government, it's often tempting for executive government to assume that we are just a government agency or public servants in the service of government more generally. So working through what it means to serve the Parliament of the day and the complexity of the employment arrangements in some of the other aspects like members' staff, for instance, there is a degree of complexity there. So we would expect that we are served by people who understand that complexity.
And you know, that instinctively makes sense when you think about the claims of like bullying, harassment, etc., particularly where there's political implications for some of those claims if it involves members.
Exactly. And the status of members who are in some ways the employer of their staff, but in other ways not the employer of their staff. So understanding the complexity of that. As we've talked about before with work health and safety, I think Mr. Dadham's often asked where the balance of liability around work health and safety and the rest lies, and of course the answer is it lies with all of us, depending on the context and the nature of the concern. But that is complex, and so I must admit, while the team will get me details about what the mechanics of this switch over and why we made it, why this, I mean, what I'm taking from your question is kind of a why now, why not at any other time, and I'll definitely get those details. But I would put to you, generally speaking, that any time we interact with any element of either the executive government or in this case insurance, we always want to make sure that people understand the complexity of our environment, understand that even for my officers, we serve the Parliament of the day, not the government of the day. That is a subtle distinction, but a distinction that a lot of people don't really understand. And so being able to work through even that implication is something that we want people who are going to provide us services, whether it be EAP. So, for instance, we picked the current EAP provider because they'd been serving the Victorian Parliament for a while and had a better understanding than other providers about the unique nature of the parliamentary workplace. And it turned out that understanding the Victorian Parliament was a better mechanism for understanding us than, say, working for a government department in New South Wales because of those unique complexities.
So can I ask, obviously under the Workers' Compensation Act, for most employees, you get a 6-month protection from unfair dismissal after you've made a workers' comp claim. That is not necessarily the case when you're dealing with a staff member for a Member of Parliament. What protections do injured members of Parliament's staff have in that period from unfair dismissal after making workers' comp claim?
Yeah, so you're quite right in saying there's real complexity there. Just for completeness, I would say that all of the normal provisions apply to parliamentary staff that work in the 3 departments and the like. But you're quite right. The interaction between the MOPS Act and the power of the member to dispense of the services of somebody versus the requirements under the Work Health and Safety Act are complex and never fully tested. So what would come out supreme if it was tested is an interesting question that I can't answer because it hasn't been tested. We certainly recommend to members under circumstances where those kind of circumstances can arise that we give effect to the spirit of the Work Health and Safety regime, and most members agree with that. I think with some of the flexibility I talked about before in terms of administrative arrangements, it does mean that if somebody is on workers' compensation not able to attend work or in a member's office, I have more flexibility now to make sure that doesn't come at the expense of the office more generally, so we're able to backfill the positions in a more expedient manner than we've been able to before. But your question is a really good one. To be perfectly honest, I don't really know who would win, MOPS versus Work Health and Safety. I'm not sure what would happen. Like many things with the Parliament, until they're tested somewhere, we try to assert what we think is the right thing to do. And in this case, we advise members to give effect to the spirit of the Work Health and Safety legislation. And as I say, the vast majority of members agree with that premise and work in that way.
So coming back to the iCare Specialised Claims team, so as I say, instinctively, yes, they are complex cases. I guess the counter to that, though, is that that iCare specialised claims team is more centralised within iCare itself as opposed to being with an external party. There's a perception that could actually lead to more political interference than less. So I guess, so who initiated that be transferred and how do you protect against that political risk?
So I'm just getting a few details about the initiation of it. It's an interesting point that's not been raised with me before. We're very clear in stating our expectations around how cases are managed and the like, and the lack of political interference is at the top of that list. But I do take your point. You're concerned that because the unit is a little bit more centralised to what is essentially a government-run organisation, is there the potential for conflicts of interest there? We haven't come across any so far, but that is something I'm happy to look at in more detail.
Thank you. And when you come back with the details on what initiated it, it'd be useful to know, I guess, was there an increase in particular types of claims, or was there some sort of increased cost in total workers' compensation payouts? What was?
Yes, what's going through that? We can look at that as well.
Okay, just coming back to the members' staff conditions of employment, which I know Mr. Namber was touching on earlier. There is an ongoing frustration from member staff with the pace of change, and so a lot of people saying that they have had, they've given the same feedback to surveys for 5, 7, 10 years, and there's just been no improvement in things.
So I'm not sure if you heard the comment that I made to Mr. Nanva, which is this. Very clearly, the time for consultation is over. We have done a lot of consultation. It has been very important, and the point that Mr. Nanva made before is one that I adhere to, which is that some of it previously, it wasn't representative, but I now feel as though we have a very clear representative sample and an understanding broadly of what the views are of staff and members. And so we're now moving to the next stage, which is, of course, engaging with the government to try to land this position.
In the town hall meetings, which I understand were people were glad to have to have town hall meetings where they could talk and hear sort of what the latest is. there was some frustration that there was no mention of the very strong feedback from staff that they would like to be covered by an industrial award. Now, I understand that is outside of the remit of this particular review, and that would require
Legislative change. Yes.
But given your experience going through all of this, would you support or make a recommendation to government that really these staff should be treated under an industrial award just like they are in every other state?
So the short answer is no, but the longer answer is I'm not opposed to it. It is entirely a matter for the government / the parliament about whether it wishes to go down that line or not. And if that were the case, I'm sure I speak on behalf of Mr Webb when I say we will ensure that we enact it perfectly. Can I say on a personal level, if I didn't have responsibility for the determination anymore, that wouldn't necessarily be a bad thing.
Thank you.
Thank you, Mr President. Mr Rath, welcome.
Thank you, Chair. I wanted to start with whether there's any progress being made on electronic SO52s.
Before Mr Reynolds answers, which he will, can I say that this is the first budget estimates that I've been involved with since 2023 that we haven't discussed the lifts yet. So I'm delighted about that, and that's where I thought you were about to go, but nonetheless,
no,
here we are.
I think
it is on my list.
Is it? I'm sure it is.
Double opened on me this morning.
Slowly. I'm sure it is. Mr Reynolds.
We would love, I should say first, we would love to have e-returns. If any member has been in the clerk's office to look at privileged documents, you'd see that we're, from the roof to the ceiling, we've got archive boxes of documents. At the most recent budget estimates, I detailed work undertaken by the Procedure Office to date, which included an initial review of the concept of e-returns via SharePoint, which is a new direction, if you like, a simpler way of doing it. The review assessed how documents would be viewed and managed if physical boxes of documents were replaced with folders of electronic documents transferred via SharePoint, informed by the rollout of the Members Hub for committee information. Access and security considerations for public, privileged and personal information documents were also assessed, as were related IT needs, such as having a dedicated restricted access computer in the clerk's conference room for members to use when looking at privileged documents. The initial review indicated that current practices for secure viewing of privileged and personal information documents by members and the viewing of public documents in the Procedure Office reading room could be adjusted should documents be delivered by SharePoint, and that the new system could be supported by department staff. At that last hearing, I noted that we'd had a meeting scheduled with the Cabinet Office. I can inform members that we had that meeting with the Deputy Secretary of the Cabinet Office, General Counsel and other representatives in September to discuss the project, and at that meeting they were generally supportive of exploring the delivery of e-returns via SharePoint. We had an initial project meeting on the Thursday the 4th of December 2025 by the two teams, the Procedure Office team and the Cabinet Office team that deal with Standing Order 52s. At that meeting, a detailed project concept was discussed. The Procedure Office is now working to formalise the project scope ahead of further progress on the project this year. So work is ongoing. We hope that by the next estimates meeting we can have a very concrete advice on this, and all I can really say is that at the department level, Cabinet Office are supportive of us trying to proceed down this SharePoint route.
Thank you. Thanks for that update. I mean, I completely understand some of the sensitivities with privileged documents and personal information documents, but surely in the interim, it's quite easy to put the public documents whilst we sort out a more elegant solution for the privileged documents, surely the public documents at the very least could be put up on SharePoint.
They can't really be done in isolation because of the nature of the indexes that are provided for all the returns. Would have to... the access to electronic documents will be structured in the same way that the Members Hub for committee information is at the moment. So you would have folders, and some of those folders would be public and some would be privileged and private. I don't think Cabinet Office are interested in separating the two types of returns. Like it's either one or neither.
Yeah, at the moment there's, with the public documents, we've got
Scanning
public
machine.
servants that have to print off all of their documents, emails, correspondence, which then get put into boxes that aren't really big enough to fit the amount of documents that we have, which then get carted to your office, which then either me or my staff need to go to your office to then scan them all and put them up on SharePoint for others to take a look at, which seems like it's just a completely absurd system, at the very least for the public documents, that it's lots of printing and scanning of documents that already exist in an electronic form.
And after that, there's the final stage where when members have and others have finished with documents, we then have to rebox them to send them to state archives, because the archive boxes that we get aren't the state archives want them in sort of larger boxes. So there's a further stage of paper handling. So you're quite right, it is absurd what we're dealing with at the moment.
Sorry, Mr. Rath. Yeah. Apologies, colleagues. I just have to step out. This is a matter I have to turn my attention to just for 5 minutes. So we haven't elected a deputy chair. So do I have a nominee for deputy chair just to fill in for 5 minutes? It has to be one of you guys.
Oh, sure.
I nominate the Honourable Chris Rath as the most sensible nominee for the deputy chair.
It's a very high threshold.
It's a high threshold. Do I have? I'll put that then. That the Honourable Chris
Come
Rath
on, Bob,
be
nominate
elected
yourself.
Temporary deputy chair of Portfolio Committee number 1. All those for against declare that carried. Thank you. We're in your hands, Mr. Rath. It's the government.
Fast, very impressive.
Thank you.
So behave.
It's the.
I'll be back in.
It's a nameplate of power.
It's a tremendous honour.
Add something on Stephen's response. Care also needs to be taken to make sure that we don't inadvertently introduce any cybersecurity risks with any solution going forward. So even with the public documents, it's been my recommendation to the clerk that we pay particular attention to any cybersecurity risks that might come up with any solution that comes through as well.
And probably I should also mention that every now and again we get contacted by an agency saying, "Whoops, sorry, we've put accidentally put a privileged document in the public documents, and can we retrieve that and move it?" So. There's complications, and that's also, I think, a factor in not being able to do one without the other.
I also need to make sure any solution is sustainable in the long term as well. So the system has to be built not just to meet the immediate requirement, but also so that it continues to meet that requirement moving forward. It is, I would, certainly my advice to the clerk is very much that we make sure that all those cybersecurity issues are dealt with, and that we make sure that any solution that's put in place is sustainable in the medium to long term, because the public service is littered with systems that were put in place fast and then regretted at leisure later.
If we continue down this path, has any consideration been given for a potential second scanner in the where the public documents are in the procedure office? Because sometimes it can become a bit of a bottleneck if multiple members and staffers are trying to use the scanner. Ideally, we wouldn't need it if we're going to publicly electronic documents, but in the meantime, maybe if you would like to consider a potential second scanner.
I'll take that on notice and discuss it with our staff in that room. I think the original scanner came about as a result of a request by an opposition whip in the last Parliament. So,
All right. Well, in that tradition, the opposition whip is now requesting a second scanner.
Well, in the last budget estimates, we got a new microwave for level 11. The one before, we got a new pin board for Mr. Primrose's office. So surely, Mr. Reynolds, we can get a second scanner out of this budget estimate.
Lounge too.
With
Say again?
We've got a printer for the members' lounge. as well.
100% through Dr. Conn. That's exactly right.
Yes, it's
Mr. Rath, if we possibly can, we will do so.
All right, thank you. If just on the what was mentioned before about a privileged document in a public box, what happens in that case if it has already been, for instance, scanned and distributed? I mean, I would say it's usually the other way around, where the government's overly privileging documents that don't need to be privileged, but I take the point that there might be the odd occasion where it's a privileged document in a public box that could inadvertently be released.
why might you suggest that, Deputy Chair?
No, I'm just that was the comments before from the witnesses.
That the government overly. Yeah.
in that instance, and it is rare, but it does happen. We ask Cabinet Office to make effectively a fresh return for those documents, so they have to issue a new index indicating the documents that are required to be moved. They have to make a claim of privilege over those documents. Once we get that, we would then move those documents, and then we contact anyone who has previously looked at those documents and advise them of the privilege status of those and ask them not to make those documents public. But I mean, obviously, timing is an issue. If people have looked at and distributed those documents before the claim has arrived, then it's often too late.
Yeah, fair enough. I think everyone's seen the changes to Hospital Road entrance and the upgrade of Cafe Quorum. What work is being undertaken? Why is it being upgraded? What's going to be different about, or what can we expect will be different about Cafe Quorum when it's renovated, and when can we expect it to reopen?
Thank you. I might just make some comments to start with and throw to Mr. Webb. The first is, can I thank all members of the parliamentary community for their forbearance with this. This is a very important set of works that's being done, but obviously it's had an impact, first and foremost, on access to the building through the Hospital Road entrance, and the second is through a catering offering, the cafe, and so we understand that. But it was incredibly important. It was incredibly important for a number of reasons. The first is in terms of accessibility compliance. We needed to ensure, and always need to ensure, that we're compliant with the Disability Discrimination Act. We need to make sure that we have accessible wider doorways, we've got DDA compliant point of sale areas, we've got accessible seating and so forth. So the accessibility for both the cafe and also for getting into the building itself. As Mr. Webb likes to say, whenever we solve one accessibility problem, we then often find that there is another accessibility challenge to be resolved straight afterwards. And so fixing, for example, and making, and correct me if I'm wrong, Mr. Webb, making the Hospital Road entrance one where the door can be opened automatically rather than you needing to physically pull it is an important part of that. It's also important for a range of work health and safety issues, particularly in the cafe. There's there were a range of things from old equipment to sleeping hazards to manual handling risks in the cafe through to ergonomic issues from outdated security workstations in going into the Hospital Road entrance. So the WHS issues were significant as well, much like they were with the Long Bell Cafe. So for those two reasons, that's why we determined to do this. We wanted to do it over the most convenient period possible, which we felt was over the Christmas break. When you rightly ask, will it be completed? We envisaged the work will be completed well before the sittings in May. So hopefully there's only another couple of months, and then we're done. I guess the final point that I'd make is, on top of those two things, we then have the excellent opportunity to ensure that it's actually aesthetically improved as well. And so it means that security will be improved, accessibility will be improved, WHS standards will be improved, but also the Cafe Quorum will actually look better, and we'll have an opportunity to make it a nicer place for people to be able to spend time. But Mr. Webb may have more comments to make.
Oh, you're not leaving me with a lot, Mr. President, I must admit. But the point about accessibility, just to emphasise that, when we changed, you might recall when we put the turnstiles out the back, and we made sure that that was accessible, but then that highlighted the fact that a mobility impaired person couldn't get from those turnstiles to the back of Hospital Road. So when we had the opportunity, we put the ramp that goes up there, which is fantastic. But as the President said, that then leads you to probably one of the least accessible doors in the parliamentary precinct. So being able to, I think we have now a real track record of making incremental accessibility upgrades to this place that take into account the heritage. I think this committee's heard me say before that when we put that ramp in, for instance, as it turns out, because of the makeup of the tower block, pebble creeting is a heritage item of our precinct, and so we had to get a pebble creeter out of retirement to come and help put that ramp together. So the challenges of making changes in a high heritage impact space means that progression and that consistent and constant focus on improving the way that this place operates and the accessibility of this place. I'm really pleased to say that once we finish the Hospital Road entrance, that will be the last step of that link, and so someone with mobility impairment will be able to come from Hospital Road all the way through for the first time first time ever since the tower block was first
and
created.
And that's May, so the Quorum and Hospital Road, we're predicting
May.
Expecting about May, and then that will change the temporary arrangements on level 6 with security.
That's
there,
correct.
I assume, back to the way it was.
Yes, that's right. In fact, slightly enhanced. It'll be, the security setup will be smoother and easier to get through at that point.
By popular demand, would you like to give an update on the lifts? They seem better.
Yep,
maybe not perfect, but they're definitely better than they were this time a year ago.
Happy to. They're updated. They're fixed.
They're
done.
entirely fixed.
Well, Mr. President, that may be somewhat disputed, because this morning I did hop in the lift on level 4 and was diligently making my way, albeit somewhat late, to the deliberative for this very meeting, when the doors shut. The doors then opened all of a sudden and then decided to shut again and take me to where I was seeking to go. So there does seem to be one or two little gremlins there. Are we still receiving service and support from the lift companies to ensure that the gremlins are ironed out?
I don't know, but thank you for raising that gremlin. And if anyone else has noticed any gremlins, please let us know.
Says it's going up when it's going down.
So the short answer, the serious answer is they are significantly better, obviously, and there's been massive improvement, and it's wonderful. But of course, with any change, there's going to be the odd potential little bump. Thank you for raising that. We'll certainly look into it. And if anybody else has any other issues, they should let us know.
It was the middle of the north-facing, the north set 3.
The north set in the middle, right?
Yeah.
We'll get someone.
I'm not suggesting we drag someone out.
No. We'll get them,
but we'll
as
feed
part
it
of
in, and we appreciate
absolutely.
that.
That's right.
But just as an example, for instance, you mentioned the going up, going down thing.
Yes.
That issue issue should now be completely resolved. So we were able to find there was a programming issue that was causing that to happen in a very limited number of circumstances. But we'll look into this one as well. So
Well, I can give you another one. Yesterday, I pressed the up button, the lift doors opened, the indicator didn't go either up or down, it was just blank, but there was somebody in the lift with levels. I was on level 7, level 6 was pressed, so the lift was going down, but there was no indication on the outside of the indicators.
Would you remember which one that was, Mr.
I believe it was, of the 3 that were on the north side, the first one, so the most left, which of course would be the most problematic one.
Yeah.
happy to look at any issues that come up.
The left one, yeah.
As well.
Yeah, no, thank you. That's very helpful.
That's all right. I have a photographic memory for these things, lift problems.
Late night sittings.
Yeah.
And I know the procedure committee will start to look into this, of which I'm a member, and I'm looking forward to that process.
Really?
But what, I suppose, for the members of the committee to understand a bit better, what sort of arrangements are in place when we unexpectedly sit late? I mean, obviously we know our staff often have to sit late when we sit late, but what does it mean when there's an unexpected late night sitting for Hansard, for catering, for attendance, for the clerk's office, etc.? What impacts does it have, especially if you might not know until sort of 10 or 11 a.m. the morning of that you could expect a late night that night?
Thank you. It's a very important question, and I, as you know, I referred this matter to the procedure committee. It is obviously a determination of the House if it wishes to suspend its standing orders and therefore suspend the heart adjournment, and so therefore, in terms of the impact that it has on the staffers of the members of the Legislative Council, they should. I mean, that is entirely reflective on their member. Although that having been said, there are some ameliorating impacts that we can put in place. But your point is 100% correct in terms of the impact on people who are outside of the political fray and are just trying to do their job. So I might ask Mr. Webb to start and talk about the impact on DPS first and what you put into place to deal with that situation, and then Mr. Reynolds to deal with the Department of the LC. But thank you for raising it. It is an important question.
Absolutely. And so I'll start off by saying, obviously, the earlier notice we get of potential late sitting, the better prepared we can be for that late sitting. But we do recognise that sometimes the decision to lift the heart adjournment depends on the ebb and flow of what's happening in the chamber, so sometimes it's unavoidable that those decisions get made a little later in the day. So there's impacts on a couple of main areas. So the ones you've mentioned, the Hansard side of things, also our broadcasting service people, the catering team, and as well as IT services and the property team. So they're the 5 primarily impacted parts of DPS. I'll just very quickly run you through a couple of the fatigue management processes we have in place. We have for each of those areas a much more comprehensive fatigue management process, which I could go through, but the committee would have to grant me an hour or so to go through everything, but I'll try and give you a potted summary at the top. So on the Hansard side of things, we have a 55-hour cap on how many hours an individual Hansard reporter can work in any given week. That is very closely monitored. When people get to around the 50-hour mark, that's when we start to pay particular attention to that. There's a minimum break between shifts, as you would expect, but that was not always the case if you go back into the past. But probably most relevantly for the committee, we do tend to cut off transcription at midnight if the sitting is going beyond midnight. So we will transcribe up until midnight, and then we send the team home and they pick up the transcription again the following morning. This means that everyone's getting a break that they need to have. It does mean sometimes a slight delay in the transcript, although I remind everyone that we have the Parliament on Demand system that allows you to look at the video proceedings of what happened the night before if you really need to. Usually a couple, but if we are going to send everyone home after midnight, we do need to keep a couple of people in place to log what's happening in the chamber or the chambers. So that's 2 people per chamber. So if both chambers were going all night, it would be 4, but usually it's only one chamber that's going late. So 2 volunteer sub-editors usually stay in order to do that logging, just to make sure. It's the kind of thing where it might not be clear from the video or the audio about if pandemonium was to break out at 3 o'clock in the morning and it wasn't entirely clear who was saying what where. The loggers are the ones that say, Mr. Murphy said this, Mr. Rath did this, basically allows the people doing the transcription the next day to make sense of what they're hearing and seeing going through. And of course, as is the case, and I'm sure Mr. Reynolds will talk about this as well, anyone that works past 8 o'clock does get the capacity to take a cab home. We've also been experimenting with if the person's required the next morning, whether or not they can get a cab back again. In some cases, we don't use this so much, but in some cases, if there's a particular need for a particular person who lives a particularly long distance away, whether we look at a hotel overnight for that person so they don't have to travel all the way back home and then back again going through. Very similar with AVB. We have both in Hansard, we have a small casual pool in Hansard so we can supplement our resources if we need to. AVB, the broadcasting team, have a bigger casual pool. So if there's been a notice of motion of lifting the heart adjournment the day before, we usually organise for people to start late in the afternoon, so between 4 and 6 p.m. And those people, like camera operators, etc., will then be able to do a longer shift. So we use the casual pool in order to make sure that not a single person is going through. Similar other, minimal allowable breaks, etc., for the AVB team. Catering, obviously we keep the cafe open until half an hour after last bells, and so that can mean a very late night for some people. Again, we're doing a cap of 50 hours there and minimum breaks, but we now are able to use, because we have agency staff who work with us for events and functions and the like, we're able to bring people in to start a shift at 4 p.m, between 4 and 6 p.m. if we're anticipating a late night, so that people aren't working all day and then through the night as well. And then IT and property support is provided over the period. Again, there's someone from the building team is here until after last bells, somebody from the IT team monitoring things till after last bells. We use a rostering system to make sure that people aren't working too long in that space. So, look, I could talk about this for a long time, but comprehensive fatigue management practices in place for each of the areas. I do recognise that means, so for instance with Hansard, it means that there can be a delay in the transcription, but my primary focus for my team is making sure they are safe in the work that they are doing, and I definitely stand behind all of those measures. The safety of my staff is of paramount importance to me.
Thank you. Mr. Reynolds?
For our team, there's essentially 2 teams that are affected by by very late sitting: the attendance chamber support staff team and then the procedure team that supports sittings of the House. Both those teams have to have at least some staff there until not just when the House rises, but also in terms of the procedure office after the House rises, because of the documentation that we need to prepare. It's obviously a lot easier when the late night sitting is on a Thursday than it is when it's on a Tuesday or a Wednesday, as I'm sure it is for all of you as members as well. We look to send as many people home, obviously, as we can when we know that we're going to sit very, very late. In terms of John's team, the chamber support team, they go down to a very, very much a skeleton staff, and for people who are staying on, they're either rostered off for the next day, or if they're on front desk duty, they're coming in much later than normal. So people are sent home early to open up to be there for 8 o'clock the next day. With both teams. We offer hotels for staff who live a long way away, like we have staff who live in the far western suburbs, for instance, and have even by car or taxi, it's sort of almost an hour at night. So we offer the option of staying the night in a hotel if they've got to be at work the next day. We have an arrangement with, I think it's the hotel at Darling Harbour, to do that. As Mark said, we also, if it's a really late night sitting, we've gone sort of to 2 or 3 a.m, but we still need people for a sitting the next day. We, as well as offering the taxis to leave, we offer them a taxi to come back if they're a long distance away, so that they get a little bit more sleep. Apart from that, I mean, we try and find ways to reduce the demands on staff when we're sitting late. You'll probably notice during the adjournment debate, for instance, we used to have 2 people in the chamber. We now just have 1. So that allows somebody else to go home. And if we're producing the minutes, we may decide that if we've had a long and complex committee of the whole, which often is the case with a late night sitting, we might just publish the minutes without the committee of the whole part of it, and do that sort of during the day, the next day. So there's a variety of measures. We do have to have staff present till the House rises, but as to you with your staff, we just manage the best we can, and obviously we prefer it when it's a Thursday rather than a Tuesday.
Thank you, and we'll explore more in the Procedure Committee, and I'll hand over to the government for questions.
Mr Deputy Chair, before we go to the government, can I just issue a quick clarification on a particular point? So when we were on the issue about the independent complaints officer, I made a comment, I think, to the effect that the first candidate for the who'd been determined for the independent complaints officer withdrew their name from consideration, and then I think I said after the recommendation of the clerks. What I was trying to say there is that the clerks recommended the candidate be appointed, and then the member withdrew that gentleman withdrew his name from consideration, i.e. it wasn't that the clerks recommended they withdrew his name from consideration. He determined to do it, but his appointment was initially recommended by the clerks. Just for clarification. Thank you.
Thank you. If I could just come back to the answer I think Mr Webb you were providing in terms of short-term relief staff, and the loosening up, I suppose, of the requirements before a second individual could be put on. I am always conscious of the fact that when you're talking about more labour resources, which I think everyone in this building wished there were more of.
L-A-B-O-U-R or L-A-B-O-R?
Both. You can't have too many of either. Where there's a cost implication, you certainly can't will money up from nowhere. So I accept more labour resources is not a proposition we can entertain. But what I am keen to ensure is that we put the existing resources that are available to their best use. A concern I've had for some time with the short-term relief, I suppose, framework is that I think it prioritises form over substance and outcomes. And I'm not entirely sure, there may be a reason that I'm not across, but it ostensibly incentivises members to use it whenever a textbook eligibility arises to use short-term relief staff, as opposed to when the need actually arises. So there would be occasions by virtue of parliamentary committee work where we could certainly use 2 bodies to assist. And there are periods of time with the ebb and flow of parliamentary work where we'd be quite capable of not having a staffer on board if they take leave. I'm just wondering why there isn't that greater flexibility where the short-term relief proposition could be a pool of funds available to members to use most efficiently, as opposed to when a textbook eligibility arises, as is currently the case.
Mr Webb.
Yep. So really interesting points that you raise. So if I reflect on my 10 years with the Parliament, at the start of those 10 years, we have the PRT determination, which is a very black and white listed determination that said you get 1 or 2, or in the case of electorate officers, 3 or 4 staff. And very much the interpretation of that was that means at any given time you have 1 or 2 or 3 or 4 staff in play, full stop. And so the way in which the determination was written and the way in which it was enforced within the Parliament sort of led away from that more flexible arrangement that you're talking about, and led more to a black and white letter of the law interpretation of the entitlements. So I guess what I've been trying to do...
Is that taken course by virtue of a request by the PEG or by virtue of the tribunal itself? Or
Yeah.
where is that? Because it's not
from
the most efficient use of resources.
No, that's right. So the tribunal has tended to write things in fairly stark terms. It is true, and not just this tribunal, but previous tribunals as well. I don't put this down to one particular person. They have tended to write their determination in very stark terms, and I guess the interpretation by the Parliament to give effect to those rules was a practice that's been in place well before my time. This idea that if these are the rules as outlined by the PRT, then we should enforce them to the absolute extent that we could do. So I guess my pathway has been to work with the PRT to try and introduce more flexibility into the determination, which would then allow me to exercise that discretion a little bit more flexibly, as you've outlined. And so that started, as you know, with the ability to flex up resources around a natural disaster or an event like that, if there's a bushfire or floods or the like. It's extended now into this operational sort of around the edges stuff that says, if you've got somebody leaving, can we put somebody in that kind of overlap? So that my pathway has always been to work within the determination process to try and introduce flexibilities and to support those flexibilities that members have been seeking. And so that would be to move to something where it was a pool, for instance, of short-term relief that could be utilised when there are peaks of work or troughs, I think would require the tribunal to introduce that flexibility into their determination, I think, before we could give effect to it. So I would encourage any member that's looking for that further flexibility to make those submissions. But as I say, I hope my track record shows, I am absolutely dedicated to try and make sure this place works as smoothly as possible, and I'm always open to looking into options for how we can support that flexibility moving through.
So in terms of where we've got to with it, it's not that there is a obvious policy underpinning as to why it is how it is. It's just a matter of interpretation that has occurred over.
We try to seek obviously I don't want to introduce an interpretation of the tribunal's determination that then the tribunal strongly disagrees with, and then introduces something in the next determination that would send us backwards in that kind of way. So I'm always trying to make sure that we're working with the tribunal to introduce those flexibilities, and our interpretation, make sure that our interpretation is something. They won't always give a definitive position on whether they agree or they don't agree with an interpretation, but I do like to try and make sure that we're working with the tribunal in that kind of space. Because as I say, if I end up with an interpretation that wildly goes away from what the tribunal meant, then it just invites perhaps a pushback in the other direction, which I would prefer to try to avoid as much as possible. But yes, there is an interpretive element of that. As you know, the tribunal has entrusted me with managing the entitlements system directly, so I don't do it under delegation from either of the presiding officers because of the obvious conflict of interest that could come in through that. So the tribunal explicitly asks my position to manage the entitlements system, and that is the basis on which I've been able to push for the flexibility that we have introduced. I'm always open to new ideas and to support the way things go forward, but I would want to do it in conversation with the tribunal, not just unilaterally.
But assuming there aren't any significant cost implications,
Yes,
do you
of
see
course.
do you see the value in having a resource like that that can be married up with the ebbs and flows of parliamentary work rather than a textbook entitlement?
Yes,
under
that's
the
right.
criteria.
I've also, in relation to the previous conversation with Mr. Rath's question, also the consideration of what happens when there's a late night sitting, for instance. I know many of you with one staffer ends up with someone working extremely long hours. As a result, is there something we could do there where you only have one person with you at any point in time, but you're able to utilise sort of short-term relief things more flexibly to also cover the work health and safety implications? That's something that I'm thinking about at the moment, and we'll be talking to the tribunal about too. So I am always open to. I want this place to work.
Yep.
You know, like I want you to be able to do your work in the most effective way possible. I recognise, of course, that there's both a legal and a regulatory structure that sits around that, and I'm very respectful of that. My advocacy and my push is always to try and do things that will help make this place work better, and I'm always open to discussing what those things might be and how we might utilise those frameworks to push in that direction. And I think my track record shows that. So.
Okay. Well, if there's anything we can do to ensure that entitlement can be put to its most productive use,
Absolutely.
as opposed to...
Can I say members' submissions to the tribunal are incredibly important. If it's just
exactly
me,
what I was about to reinforce.
if it's just me saying tribunal, you should think this, you should think that, versus actual submissions from members saying, no, this is the way our office can work and should work moving forward. I think the more that we can make sure that the evidence going to the tribunal is comprehensive, the better from that point of view.
Could I just turn to the interest disclosure regime just very quickly?
Yep.
So could you just go through what the proposed changes are to that and when we'd expect for it to come into effect?
Thank you. I will throw to Stephen on this matter, but if I can just perhaps give you a sort of a high-level summary to start with, which is we're moving away from the current system where members produce an ordinary return each year and then a supplementary return 6 months later. Each time there's even one change, a full return is required to be submitted. This basically, new system requires an initial return, and then when a member's interests change, to update just that aspect of the disclosure. And so that's the first thing. It's hopefully going to be less onerous. The second point is that to Mr. Rath, the register will be kept electronically and will be searchable. So we can do it in some areas. But that's sort of that's a general overview. But I'll ask Mr. Reynolds to speak to it more specifically.
And before I do, can I please just remind all members who haven't put in their current return to do so by the end of this month?
Name them.
I'm one.
Yeah, there's a few people around the table. I guess one important factor of the new regulation is that the first time you'll have to do it will be on the 30th of September of this year will be in the current draft regulation. The regulation hasn't still been tabled yet, so it's not in effect. But assuming it's in the same form that has been given to the presiding officers and the chairs of the Privileges Committee, 30th of September will be the next return after this one, and that will be effectively like your primary return when you first became a member. It'll be a snapshot of your interests at that date, and from then on it's the onus is on you as members to update that return when there's a change in your interests, and within a month of that happening. You won't be required to put returns in every 6 months. You will be asked to make a statement once a year that your return is up to date, but for a lot of members it will be a much less cumbersome process than the one that you have at the moment. As Mr. President has said, it'll be an electronic one. For the first return, we won't be at the point where we can offer you the full version. What we'll probably ask you to do is fill something like an Excel spreadsheet that later we'll be able to transfer into that online document when it's ready. We would hope to have that full online form ready after the next election, so that new members will be able to fill that in, and will have transferred any information that you've provided as continuing members into that. The one thing that the new system won't have, although there's greater requirements to disclose trusts and water licences and a couple of those other things, it won't require you to disclose family interest to any greater extent than you currently have to, but that is a matter which certainly the Commissioner of the ICAC has raised that both houses need to address by establishing a resolution to have a conflicts of interest register independent of this publicly searchable disclosure regime. The Privileges Committees will be looking at that as part of their review of the Members' Code of Conduct before the end of this Parliament.
Okay. Before I hand over to Mr. Adam, I just had a couple of quick questions in relation to the ICO.
Yep.
Further to Ms. Boyd's questions. There was a concern that was looked at through the Privileges Committee around a low volume of complaints. And I think I raised this at the last estimates. And the view that it was difficult to conclude as to why there was such a low volume, whether culture is great in the Parliament or because of a perceived low confidence in the ICO process or lack of awareness of the ICO process. The previous clerk, Mr. Blunt, said that, 6 months on, I'm just quoting, we're not in a position to really know the answer to that question yet. I'm just wondering, is there any scope to survey staff as to what their knowledge of the ICO process is and to interrogate their confidence in the ICO process? Because I do note Broderick raised some questions around awareness and confidence around the mechanism that the Parliament had adopted. Given we're 12 months on now, is there scope to do a bit of a deeper dive with the staff to see what their perceptions and confidence is in the process?
I think the short answer is yes. I think that there's an opportunity. I agree with you. I agree. This is absolutely a worthwhile issue to raise. I don't know what the answer is to the questions that you ask is, but they're worthy questions, and we need to consider them. I think a couple of things just off the top of my head, but I'll throw to Mr. Reynolds as well. If we are going through this process if we end up doing what I suspect we'll end up doing, which is hopefully ratifying the potential for a short-term appointment, appointing someone into that role, then we have an opportunity to do quite a push in terms of its existence, the role, how it's utilised, what the avenues are, and so forth. So that's a good start.
Yep.
Then I would say that there are surveys which do go out relatively regularly to the parliamentary community, once a year or whatever, on a whole range of things. We had one of those last year, and I assume we'll do that again at some stage this year, including a little section about understanding and knowledge, rather than doing a very specific survey about the ICO. I think there is a little bit of exhaustion of consultation and surveys and so forth, and what that tends to flow through to is a lower response rate. So this one, though, that we do does get a good response rate, and so I would hope, Mr. Webb,
I'm not sure if we're planning one this year.
Okay.
The feedback was that we only do it every couple of years, and we did it last year. So
We'll take the
Yep.
issue on
Okay.
board. We'll certainly consider it, I certainly guaranteed the first. I have no issue about the second, and we'll look at how that might work in a practical way.
I suppose where I'm leading with this ultimately, and just please take this on notice, but I do wonder whether the trouble we've had filling the ICO might provide a bit of a circuit breaker to review how the Parliament deals with matters that were raised during the Broderick report with respect to sexual harassment and bullying, because they are quite specialised areas. They are really arduous to manage in a trauma-informed way, and I don't know that a generalist who would occupy the role of the ICO is frankly capable of doing it in a way that would give people confidence. So I do wonder whether there is scope to look at an external provider to explore matters of that nature.
Are you privatising it?
rather than ICO.
The-
You're privatising
that's-
The resolution at the moment does make provision for the ICO to engage that kind of assistance. So there is capacity within the resolution at the moment to engage specialist assistance.
But it requires people to get past their first anxiety that it's an
Yeah.
in-house process, and I'm concerned about
Yeah.
pursuing it and what that might mean for my career and potential ramifications, which goes to the confidence piece. Anyway, I'll pass on to Mr. Young.
They're valid questions, and we'll look at them.
I just wanted to ask about. I understand that there was some water damage in this room. I think a year ago or so, and I also understand that there's a member who has a health condition that may be attributable to mould in the building, and I'm wondering whether there's any process of ongoing sort of assessment of the air quality. It strikes me this building has pretty poor air circulation, so that's. I just wanted to ask about what the status of that is.
Excellent question.
It is.
So we undertake a broad-based air quality sampling a couple of times a year. So we go around different parts of the building and making sure that we're monitoring air quality from that point of view. Any time we're doing building works, we set up a permanent air quality through building works just to make sure that we're not disturbing anything that might be causing impacts on air quality. Just to your point earlier, I think the issues of the member in question you're talking about weren't caused by the air quality here, but they were certainly exacerbated by the air quality here. That is absolutely the case. Since we've made the upgrades to the Legislative Council chamber and also that corner of the building upstairs from the Legislative Council chamber, that member's not had the same reaction that he's had in the past. So there's good evidence that we are improving the air quality all the time, but we do have a monitoring regime in place. That's
Is there mould
constant.
in the building? Like, is that?
I'm sure somewhere in the building there will be a little bits of mould, but nothing like there was even 5 years ago. So one of the things we did when we rebuilt the Legislative Council chamber is we looked at the air. One of the issues was the airflow under the chamber was contributing to air quality. So we looked at a different air intake and different, and the bottom was designed to allow flow through. Even just things like removing some of the paint from the sandstone around the building has made a difference. The paint locks moisture into the sandstone, so being able to take the paint off the sandstone means that the space breathes a little bit better. So we're constantly looking at air intake, airflow. For instance, the air intake for the Legislative Council chamber prior to the changes we made a couple of years ago the air intake was in a garden area. So if there was any spores or anything like that in that garden area that was coming through, most of it was being filtered out by the air conditioning system, but enough of it could still get through to impact air quality as well. We fixed that as a part of updating the chambers as well. So it is an area that we're constantly looking at. One of the under the surface projects that's going to come up relatively soon is the air conditioning system. It's well over 20 years old and getting towards end of life. So looking at modern filtering and the like to further improve air quality is something that we're looking at as part of that project as well.
I should say though, sorry, Mr. Beth, I should just say that if any member, or in fact any member of the parliamentary community, the parliamentary precinct, has a specific concern, they should always raise it immediately, and we'll deal with it if we possibly can.
And before we move on, just a question that Mr. Namber asked earlier. I have a little bit more information if the committee is okay with me. It should only take 30 seconds. I am reminded when you were talking about flexibility in the use of staffing, one of the pieces of flexibility we were able to introduce recently, in talking with the tribunal, it used to be that if you have someone away, you could short-term relief for the day that they were away, and that's it, full stop. We talked with the tribunal, and one of the conversations we had was the tribunal had said, well, the short-term relief should be proximate to the absence, but doesn't necessarily have to be on the day of the absence. So it gave us a bit more flexibility now. So we've put in place a regime where you can essentially bank for up to a couple of weeks the short-term relief days and then use them within it. So it has to be proximate. You can't like bank up and then have like 6 months later bring things. It's within a couple of weeks, but it's just an example of some extra flexibility we've been able to introduce by being able to have the conversation with the tribunal to say, well, your intent behind saying that someone has to be there on the day is more that the work that should be done needs to be done. If we could add a little bit of flexibility, that would mean that if you've got someone who's away for a few days but you can't get somebody in straight away, or you know it's going to be a big week next week, you can bring in the second person the next week and go through there. So just another example of the kind of flexibility that we're aiming to try and introduce as we move forward.
That's really good. I didn't know that.
Yes.
We now have, I've been told, 20 minutes for the crossbench, and
Thank
then
you.
whatever time's left over until 1 p.m. we'll divide up evenly between us. So, Ms. Boyd.
Great, thank you. Just on that topic generally, is there still asbestos in the building?
Sorry, Mr. President.
Please. I will not be answering this question.
Yeah, that's right. The President's always happy for me to answer asbestos-related questions. So there is no loose asbestos left in the building at all, full stop. The last bastion of it was the balcony outside of the front. We found when we went to fix fortunately no one's been allowed on that balcony for many years, not because of potential asbestos, but because structurally it wasn't safe. When we went to fix the structural issue, we found a whole bunch of, it was a good combination. It was a combination of asbestos dust and lead dust.
Nice.
Excellent combination. You might have noticed I had to reintroduce some scaffolding and completely bag up the whole area while we removed quite a bit of that dust going through. That was the last bastion of any loose asbestos we know about in the precinct. There are a couple in some of the eaves, and the rest is a couple of areas where there's some bonded asbestos. So as long as we don't disturb it, it's fine. And then as we
On the members' balconies.
balconies, for
Yeah.
instance, yes.
Yeah.
So as for those of your colleagues that were up on level 12 when we were redoing the balconies up there, we replaced all of that as a part. So progressively, anything that's bonded, we have clear safety protocols in place in terms of works that happen around bonded asbestos, and then progressively as we do works in those areas, we're replacing that as well. And I think I've mentioned before, one of the mysterious issues we had for a little while is we did find asbestos dust in some of the air vents down in the car park, but it turned out brake pads used to be made out of asbestos. And so back in the 70s, the early 80s, sorry, until asbestos was banned, cars coming down into the car park would lean heavily on the brakes. As you imagine, it's a steep coming down there. Enough dust from that had then been drawn into the air intake vents, and because there are parts in those vents and ducts where the airflow isn't as strong, it just had been there for 20 years or so. So it took us a little while to work out how the hell asbestos dust got down into the car park, but we eventually worked it out, and that was all cleaned out as well. So that was a few years ago now. But that and the balcony were the two main parts of the where loose asbestos was in the building. Now, the only other caveat I would put to that is every time we knock down a wall somewhere in Parliament, I'm never 100% sure what we're going to find on the other side of it. As a result of that, we have very well advanced protocols for the dealing of foreign substances that anyone finds in any building works at all. So if a builder, part of the induction of a builder who comes on site, if a builder was to knock down a wall or find some substance, some dust or something that they weren't familiar with, we have very, very advanced protocols for immediately stopping work, sealing off the area, having material sent away for testing. We very much err on the side of complete safety when it comes to that kind of things. I know it's something that Rob and the team take incredibly seriously, both for their own work and for the work that they have done by builders, as does Helen Ross and the team on the property and maintenance side of things.
So, just a final question in relation to the air conditioners and air quality, just to settle a few ongoing arguments. The 10th of September incident last year, where we had the smell of smoke coming in during the firefighters' presumptive cancer legislation. What was the cause of that smoke smell?
Please.
So we've determined that someone somewhere in the building was smoking near an air intake.
Cigarette?
Yes, that's right.
What sort of cigarette?
Not the type you're hoping for, Mr. Buckingham. So,
Thank you. I've won that battle.
We can't determine exactly. There's several air intakes that could have been near. We've gone through and put more prominent signage again near each of those air intake areas just to make sure that smoking is not allowed. We're also looking at, this will be for the future, but we're looking at the air intake. We moved the air intake for the chamber to improve the air quality from the garden. We're just having a look at where those air intakes are and whether or not we need to make any further adjustments to move them away from. Even though people shouldn't be smoking anywhere near them, we don't want there to be any more disruption to the chamber. So if we need to, we will move the air intakes further to get away from that. But yes, I think it is fair to say that somebody somewhere was perhaps doing the wrong thing. And I would encourage, if you see anyone smoking anywhere in the precinct, please remind them to not do so within 4 metres of an entrance or anywhere near an air intake.
Which is also in a very quick way, an opportunity to just note the new smoking policy, where we are now compliant with the law, which is an excellent thing, but it means that the number of places that you can smoke in Parliament is now quite significantly restricted.
Can people still smoke on their own balcony?
No.
Good, because that was driving me crazy. It kept wafting in.
Particularly my old neighbour.
Okay, so
I should just quickly mention that policy is available on the website,
the
internet for anyone to look at.
very good. Okay, just coming back to the ICO questions. So when
Before Ms.
yes.
Boyd, before you do, can I just make sure that you heard my clarification before?
It's been conveyed to me in short form.
That it wasn't the clerks who tried to convince this person to withdraw. The clerks recommended the initial appointment, and the person then determined that they would withdraw.
How long has there not been an ICO then in that role? How many months are we looking at?
Rose Webb's appointment ended at the end of September.
Last year, that's right.
Okay, so we're looking at 5 full months where there hasn't been. So we know, and I'm aware of at least one complaint that was left hanging before the ICO left, or before Rose Webb departed. How many complaints, even just a ballpark figure, have been received since then that are being parked?
I'll throw to Mr. Reynolds on ICO-specific questions. Obviously, I don't have oversight on all of the, for obvious reasons, which is why it's being handled by the clerks.
I'd actually say that no one on this table would know that because there's a designated person. I think Rose Webb's number is still on the intranet, so if somebody rings her, she then refers the person to this senior officer in DPS. We could probably take it on notice and ask. I think it's probably valid that the committee knows how many complaints are held, because Rose Webb did report quarterly to the Privileges Committee, and then that was tabled in the House how many complaints were received. Obviously, the nature of the complaints is confidential, but I think we could take on notice and consult the person in Mark's executive team and ask them how for a number.
So those complaints, though, are just sitting there. So I guess, so there's 2 issues here. So one is what has been communicated to staff so that they actually know what they're doing. So if they have a complaint and they go and they have a look at the intranet, it's not clear that there's not a current ICO. So I guess what communication has gone out, and I know you've been waiting to fill the role and things have
and we've
moved
progressed
out of your
twice and
control.
we're
But
hoping-
yeah, where's the communication to staff about what is going on?
Do you mind?
No,
What I would say to any staff listening is that it's still important that people, if they have a complaint, lodge it through the mechanisms that are available on the intranet now. That's because the resolution of both houses gives a time limit in certain circumstances. One of the things we have communicated, while I don't, as Stephen said, appropriately, I don't know the details of complaints that have come in. The protocol that we put in place is that communication goes back to the person making the complaint that says there is currently not an independent complaints officer, but your complaint will be deemed to have been lodged as of today, so that when there is an independent complaints officer, they won't just turn around and say, oh, because you didn't lodge it within 21 days after you finished working here, it doesn't count. So we provide that, and also just make sure that we are if it's an internal person, making sure people are aware of the support arrangements that are in place. So if you need support in the meantime, EAP, etc., etc. If it's we don't make any judgments about or any assessment of the complaints when they come in. So one of the things I know Rose Webb had to deal with, of course, is people making complaints that weren't within her jurisdiction, so external people to the Parliament, etc. We don't make any judgments about any of that. So if it wasn't, theoretically, if an external person was to lodge a complaint, they would just get we have received your complaint, and when there is an independent complaints officer, they will look at it.
Okay.
It's likely that in that situation, the independent complaints officer would say, this is not within my jurisdiction and therefore I can't act on it, but it's not for us to make that determination. It's up to the complaints officer.
So a person who made a complaint beforehand, and that complaint was sort of mid-process, I guess, have they been communicated with so that they know what's going on?
My understanding is yes, but I will check on that because I have tried to keep myself distant from it because I take very seriously the independence of the process and the fact that it needs to be at arm's length from the Parliament's administration. So we've tried to maintain that that principle through the work that we've done. My understanding is that there was communication when the ICO first finished, but I can check to be whether there was any subsequent. Obviously, this is going on longer than we had anticipated that it would. So it might.
And can I make the point, Ms. Boyd? We are trying.
I know.
We have tried twice to identify, recommend, and appoint a permanent position. It's fallen over for reasons that I talked to you about.
No.
And now we're trying to find another solution to at least take us to the election to deal with exactly the sort of issues that you're talking about.
And I have a lot of sympathy for that. I don't think you can't appoint the wrong person.
Indeed.
That's not going to work.
Tried twice.
Is there, though, I guess what I'm concerned about now, though, is that this process was put in place that perhaps people are reliant on or see as being the option for them. And now, because of a lack of communication, they don't know what's happening. So I guess my other questions are, is there an escalation for acute cases? If somebody is complaining about being bullied and they're still in that situation, sending them off for EAP, that's maybe going to help a little bit, but it's not going to get them out of that situation. So how do we then take that presumably back to the processes we would have had before the ICO was put in place to ensure that work health and safety obligations have been complied with from your perspective?
That's right. So you're right, it's a complex situation because somebody lodging something with the ICO, we're trying to stay at arm's length of that, but if it was, for instance, an internal person, we can provide levels of support to somebody and make, as you say, prior to the ICO, we used to make informal interventions. We couldn't do anything formally, but we would make informal. And so those options are still available to us. It's tricky. It is tricky because we want to respect the privacy of one process, and so trying to encourage people to also approach us separately. Like, so you've lodged with the ICO, we would really encourage you, if you need support, to approach us separately to that, because we're trying to keep that principle of separation and the independence of the office.
And so I think that's the point here, is that the better the communication with complainants, then the more options they have, and they know. And I know, again, sympathy for the fact that you don't know when you're going to have an ICO, but I think if there's that honest communication back, then they can then decide whether or not they want to try a different path.
So those points are very valid, and we will go back and do what we can to ensure that there is appropriate communication with any of those people.
Thank you. Can I ask you about, there's something I understand called the Parliament Joint Consultative Committee.
Correct.
How is the membership of that determined?
Mr. Webb?
Yes, so this, like a lot of public sector agencies, we have a joint consultative committee, which is, for those that aren't as familiar with the industrial landscape, it's a meeting between management and unions and union representatives within our Parliament. So in terms of the union and union representatives, it's up to the union to determine who their delegates are for the purposes of the JCC, so we don't dictate one way or the other. The primary union that's involved is the PSA, of course. But our Hansard staff as reporters are also covered by the Media Arts Alliance union as well. Generally, I think the two unions work together to make sure that there's coverage in the JCC. So sometimes it's not always that both the unions are directly represented there. And then on the management side, the head of the people function is the chair of it from our point of view. The clerks and I on rotation, one of us turns up to each meeting to make sure there's also senior leadership representative there for the first part of the meeting, and then as often in most JCCs, we then leave the committee to get on with their work after we've been there for a little bit.
And is it only DPS staff reps, or is it also, is there a members staff rep as well?
Yes,
There is.
Again, it's up to the union to determine who those are, but every JCC I've been to has been a combination of parliamentary staff, so people potentially from either the House departments or DPS, and members staff as well.
Okay, but it's completely up to the union as to who
that's
they
right. We do not dictate
sort of
it
nominate.
one way or the other. The only time where there was someone who switched from being a member staff to being a minister's staffer, and at that point we had to say, hey, they're no longer a member's staffer, they're a minister's staffer, and that's a different employment arrangement. So we did ask the question then.
I was about to say, that came up.
We don't generally speaking
That's come up
interfere
once or twice before.
with anything. We may ask the occasional question if we think there's an issue, but beyond that, no, it's completely up to the union.
No objections, Ethel?
Okay,
No?
and I think this might be my final question. Obviously there's been a lot of talk about the review of staff titles and things for members' staff. I have long advocated for a marked increase in their wages as well, because they are just so critical to the work that we do, and I think they are underpaid compared to what their skills are and what they would get in another job with those skills. But having said that, I encourage none of them to ever leave.
To go looking.
Are you?
You're going to walk into an empty office now.
Please don't leave. Are you? Have you put in a budget bid to see an uplift in staff wages?
So you may not have been here when I had this conversation with Mr. Namber. We've finished the consultation process. I'm now in formal discussions with the Treasurer about how to progress this. I am extremely sympathetic to the propositions that you put, but obviously we need to ensure that we work out a financial way through this. So that is the start of it, and we will. It may well come to a budget bid. There are a range of we will see. But we've now finished consultation, and we are now in discussions with the Treasurer.
Murphy's more likely
But
to
for
get
this
his motion
financial
through.
year?
I can't preempt those discussions. I would like to have a resolution to this issue as quickly as possible.
And I guess just a final question then is,
in 3 parts.
Yeah, and it's a final in 3 parts, which is more a comment than a question. No, I mean, we've had the discussion around WHS and the discussion around the lack of protections for people who are on workers' comp who are covered by the MOPS Act. And we've also talked about the difficulties in making complaints particularly as members' staff, because of that overriding fear in this context that they will simply could be just dismissed as a result of their complaint, which is part of why we are dealing in this complex environment. Wouldn't it all just be a lot easier if we just had an industrial award and got rid of the MOPS Act?
I refer to my previous answer.
I do have a quick update for you on one of your earlier questions, Ms Boyd.
Please.
So in March 2025, iCare refreshed their panel of claims service providers to the Treasury Managed Fund. As a part of doing that, appointing providers to the panel, they advised us that they were moving a series of agencies, portfolio of agencies, into that direct care model that you talked about. So that included the IPART, the Ombudsman and Parliament, I think a couple of extra ones. So we didn't seek to have a change or push. We were informed that our claims would from now on be dealt with by that unit. There was an overlap period where existing claims continued to be managed by the previous provider. That finished towards the end of last year, and so now all claims are managed by the Treasury, by the specialised unit within iCare. But yes, we were just informed of the change to arrangement. We didn't initiate it or have a chance to push back against it.
One final question.
In 28 parts.
That I didn't, in 28 parts, I didn't ask before. Is there a staff work, health and safety committee in
Correct,
Parliament?
yes.
And is there a member of Parliament's staff rep on it?
I'm almost 100% sure, yes, but I will check on that just to be 100% sure. I do have a couple of other answers to a couple of questions that were raised, Chair, if that would be appropriate to do now. Mr. Dadham, the last air check happened in September 2025 with no issues found, so the comprehensive check of air. That means our next one's coming up probably after estimates is finished. We'll be doing something between then and into the next sitting period as well, going through there. Mr. Namva, my very precise team have reminded me that the flexible provisions that we're talking about is a combination of things with the PRT and recommendations we've made to the presiding officers for their determination on the conditions of employment. My previous comments I do stand by. I don't like to do anything without at least engaging with the PRT, but they are quite right to remind me that it's not just the PRT that is involved in all of this, and I, of course, take that point very clearly, and hopefully have redeemed myself in the eyes of my staff as a result of saying that. And Mr. Fang, yes, the issue of doors opening and closing and opening again has been reported by a couple of people in the last little while, so we're definitely looking into that. The directional arrows not displaying, it's a particular condition that happens if you've called the lift and there's a lift on the way, but in the meantime another lift for another reason turns up at the same floor. That lift won't have a directional arrow because it's not turning up on the floor in result of your call. It's turning up because somebody else is getting off the lift or something that way. In that situation, that lift won't show a directional arrow, but about 10 seconds after you got onto that lift, another lift would have turned up, which was the one coming in response to your call, and it would have had a directional arrow on it going forward. So
I demand that it be reprogrammed to show the direction.
Direction at
I don't care the cost.
That's right, at all times. So I think that catches me up with all of the questions.
Thank you, Mr. Webb.
Minimise the things on notice, hopefully.
Thank you, the opposition. You've got half the time each.
Okay, I've only got 3 quick questions, I think, or fairly quick. The level 11 meeting room has been upgraded, so thank you for that. When will the bathrooms be upgraded and.
So yet another achievement from this budget estimates process due to Ms Boyd's advocacy that there will very shortly be 2 new bathrooms available for people on level 11, individual cubicles, which will be done, I believe, by the end of March.
That's
Such a
correct.
wild
Yep.
concept.
And so to no substantial impact at all to the meeting room on level 11. In fact, it's actually better because of now it's the screen on the wall and so forth. So I think that's a win-win for both this committee and for common sense in general.
It looks nicer too, the new meeting room.
Thank you very much.
It smells like
The
new,
smell is
Yeah,
somewhat
it's
a
got
bonus.
new,
We
leather and
we do
timber
spray
smell.
everything with
So
a new meeting room smell, so I'm glad you,
We,
glad
we,
you noticed.
we will, though, in all seriousness, pass that on to Rob and the
Yes.
Capital Works team because I'm very happy with the outcome too. And I think those sorts of things, when we can do sensible things like that within the footprint, the confined footprint that we have, it's a good thing that we do.
That's volatile organic compounds. It smells good, gives you cancer.
the
You know what else does that?
Just for the
Yeah.
record, we try and make meeting rooms that both smell good and don't give you cancer. So that is our
That
goal.
is good. Can I just add, I know it's your time, but can I just add that the people doing the construction were very polite and nice people. I just thought I'd pass that on.
That's
because
very
it
good
was-
feedback
they
too.
were- yeah.
Wonderful.
Carry
Thank
on.
you, Mr. Ruff.
yes,
What are you
the
suggesting about the people that did the work on
the
them?
SO just back on SO 52s, and I hope we'll go to digital returns at some point. But in the meantime, I suppose the only thing is, if any consideration could be given for members that might need to access files outside of 9 to 5. That's the difficulty thing. A difficult thing. I mean, we obviously try to get down there in office hours and then scan what we need and put them up on SharePoint for staff and MPs to look at. But if there's any ability, and I know it might be difficult if we need to be supervised, but with the public documents, probably there wouldn't be as much supervision, I would have thought. If there's some consideration for after hours access to public documents, at least by members or members' staff.
Mr. Reynolds?
Yeah, I was about to say it's probably easier for the privileged documents because I'll certainly be there after 5 o'clock most days. But yeah, look, we'll give consideration to it, but it's about the staff. The same staff that are working on that are also the staff that support the sittings of the House. And when you've got staff who are working till 11, 12 o'clock at night on sitting weeks, to ask them to then stay back late on non-sitting weeks as well is a big ask.
But could it be that, for instance, if I said I need boxes 1 to 10 of whatever return, I mean, and they're public documents, do we really need a staff member to stay back with us?
Yes, because effectively they're still the custodians of those documents, and not everybody is as careful and as not everyone puts everything back in the way that they should. And I think if it was unsupervised, most people are fine, but you know, we get members of the media, members of the public. It would be very tempting to just take some of those documents out rather than spend the time scanning them or photocopying them, and we'll give consideration.
Yeah,
to it,
maybe
but
just for
is-
members or
yeah.
members' staff. Like I don't think members of the public should be able to come here at 11 p.m. on a Tuesday night and rummage through the files, but but potentially for members and member staff. Otherwise, I mean, the main thing we're doing at the moment is scanning the documents during office hours so that we can then access them after office hours. But
Yeah, I mean, obviously on a sitting day, there's no issue. Staff are around. You can look at them until the House rises, but it's the non-sitting weeks that are problematic. but we'll look at it. Yep.
Thank you. And then just a final one from me, probably to you, Mr. Webb, is for all those people in the press gallery watching, they've asked whether the toasted sandwich maker in the press gallery could be replaced because it has disappeared.
Team, head down to the shops now and get a toasted sandwich maker for the press. We will make sure that is action today, Mr.
Just ask Madison.
And prepare yourselves for a lot of front page articles lauding Chris Ratt.
And Ms. Boyd, the Work Health and Safety Committee is open to member staff. Currently, there are no member staff on it, but they are welcome to be. So if there are any member staff watching who have a particular interest, please make yourself known to us. There has been in the past, but just right at the moment, there is no one from member staff on it.
Okay.
Again, one less question.
I don't have anything.
No, I'm very happy with the answers so far that I have received.
Yeah, I've got just one. I wanted to ask, so earlier we were talking about the new disclosure regime, and as I understand it, you'll have to disclose if you're a beneficiary of a trust, and my understanding is that pretty much everyone's a beneficiary of a superannuation trust, so will that mean that every superannuation fund you'll have to disclose, and to what level of detail are you required to provide? I mean, obviously, the expectations if you're running your own, family trust, there's obviously various interests, but for a beneficiary of a industry superannuation fund, that's all on the public record. So is there going to be any...
Yeah, that was raised when the initial draft regulation happened, and at that stage it did look as if there was this expectation that you'd have to, if you're with an industry super fund or whatever, you'd have to disclose all of their makeup of investments. That's not the case with this new draft regulation. As you say, if you've got a self-managed superannuation fund or some control over what the fund invests in, then you have to declare it. But if you're just a member of an industry fund or a private commercial fund, you just have to disclose the name of the fund and those details. You don't have to declare what they invest in.
Okay. That's it for me.
Mr. Murphy, no?
No.
Okay.
No more attacks on the King and Queen of the...
You want some?
I do just have one more.
Final.
Final.
In 332 parts.
We've spoken before about security issues, and I'm grateful to see the barriers put up in committee rooms, just to give that psychological barrier, at least that there's a space that the members are in and a space that the public are in. And I am a firm believer in opening up the Parliament to the public as much as we possibly can. But it's also a workplace. The Legislative Assembly members can get from their offices to their chamber without going into any public areas. We don't have that option, and we also, when we're in this particular committee room, we don't have that option either. On a number of occasions, members have been approached after leaving this room doing a committee work by somebody who's been watching them in the chamber and not always been respectful. I'm not sure there's anything that can be done about that, but that there is this increasing anxiety amongst some, particularly the women members of Parliament, that they are being put at risk by not having sort of a more secure route.
Yeah.
So I don't know how to say that in a an easier way, but I think that it's just another consideration. I think we're making good moves towards that.
Thank you. Thank you for raising it. I'll deal with them both separately, if I may. The first is the accessibility to our chamber. You're quite right. That having been said, you can get pretty close. If you go down via the clerk's office and then down those glass doors, it's literally out and around the corner into the chamber. Now, there was a specific issue that one member raised with us, and that I suspect was going to impact possibly more than one. So during that particular discussion and debate, we ensured there was a special constable placed at our desk at the Legislative Council reception area to ensure that that small gap was monitored. We are always open to looking at providing that sort of support if required, if members are concerned about getting from the glass door to the chamber, and members should know that. The second issue is obviously a slightly more challenging one, but I would say that this is also something that we are very flexible on. There was, without going into any details, there was a particular committee hearing where there was a request from the committee to increase the security focus of that hearing. A number of actions were put in place in order to do that, which ensured that the committee then ran without any issue. So I would say to all members, and particularly committee chairs, if you do have any potential concerns, you should raise that, because there are things that we can do in terms of, obviously, the placement of special constables is a start, but not the only thing. The third point that I would make is, if you are thinking about having committee hearings and you're worried about those issues, looking at utilising the Macquarie room, which then obviously has the exit that goes straight to the lift well, means that that's a heightened level of security, obviously, for members as well. And always we will do all we can to respond to people's concerns about these very issues.
And I wonder, I guess I've been thinking about ways that empower us to be perhaps able to draw those boundaries better. And one of the things I was thinking of was even just a simple sign that's like, welcome to Parliament House, but, do respect that this is also a workplace.
Yeah.
Like it's something that then you can say, oh no, I'm working right now. So that when you are moving from room to room or between budget estimates, and a member of the public has decided that now is the time, they've seen you and they've wanted to get a meeting with you and they couldn't, and now's the time to come and talk to you, that you can be like,
just
that the norm has been set. There's an expectation that you please make an appointment. I'd love to speak with you.
Yes.
Just for those, there are unfortunately increasing number of problematic interactions, and I think just something that sets the norm around this is both a house of democracy and a workplace.
Yes, I think that's a really interesting point and a very valid one, and potentially a serendipitous one too. We are currently going through a new refreshing of wayfinding throughout the building, predominantly for accessibility reasons, but also aesthetic, and we will consider that suggestion.
Thank you. And thank you for the toilets on level 11.
You're very welcome.
It's very exciting.
Chair,
I am very thankful to, and not quite as excited. But thank you,
I think
Chair,
Mr. Reynolds may
Mr. Reynolds,
I
you
have one
an answer?
more answer to a question I took on notice from Mr. Fang, which is the costs of the Cullen v President matter.
Let me get my zero ready, my zero key.
So these are the up-to-date, as of yesterday, figures. For the initial matter, that our total legal costs are $443,517.94, and to date for the costs of the appeal, we've spent $77,189.60.
Can I just ask, in those circumstances, given that the litigant receives a government grant through the Attorney General, is the Parliament able to, in a similar vein, receive through the Attorney General a grant to defend itself, given that the action, effectively, the litigant is being bankrolled by the Attorney General and the Men's Labor government? Shouldn't the quid pro quo exist and that the government and the Attorney General provide a grant to the Parliament in order for it to be able to defend itself from the actions of the Premier's Chief of Staff.
Who are you asking that question of?
Anybody, everyone can. I'll tell you what, even the government can comment. Even the government's allowed to comment on this one.
It's probably a good question to ask in the Attorney General's.
I think I might. I think I might.
All right, well, thank you, Mr. Fang. Appreciate that. Thank you, everyone. Thank you, Mr. President, for your service and for your attendance. Thank you to the witnesses. A few things taken on notice, which we will, and the Secretariat will be in contact in due course about. And thank you very much for your attendance and the work you do for the people of New South Wales.
Here.
Thank you very much.
Well said, Chair.
Thank you.